May I have your Lord's leave to mention a matter, Your Lordship, extension of interim order. Extension of interim order.
Mention tomorrow.
Tomorrow.
Thursday.
My Lord.
Mention on Thursday.
My lord, for the petitioner, my lord, this is the matter for recalling your lordship's order, my lord. I have.
Where is Mr. Mukherjee?
Lordship, I laid by Mr. T.M. Siddiqui appearing on behalf of state. I just get this CAN application, Lordship.
Yes, sir, it
Just
has
get
been
this.
filed, my lord. CAN application টা এসেছে সেটা বলুন
এসেছে?
মানে CAN application is
Come at 2. Come at 2.
Lordship, I have to take necessary instruction further. So, Lordship, kindly keep it on tomorrow.
What have we said?
my lord on
So
instruction.
now your contention is that the matter has not been disposed of.
No.
Where
that
have
is-
you stated in your application?
My lord,
Oh, application টা আসেনি তো?
Hashinit application. My lord, that is that representation of July 2022 has been disposed of. That has no nexus with my matter. My representation is of 1st February 2021. It has no nexus with that application, and my lord, the private respondents are also different. That representation is against some Jogai Tontubai and others, and my matter here is against some Gorai and others.
Or
I have to take
you ascertain this. You ascertain what because it was submitted on behalf of Mr. Siddiqui, but we have recorded.
Yes, Lordship, I today forwarded this application to
So
Mr.
you
Siddiqui.
please take instruction from your BLRO
Yes, Lordship, yes.
with a written instruction. Then the instruction which he has given is contrary to what she is saying.
Yes, Lordship.
Follow? To obtain a fresh, tell Mr. Siddiqui to immediately fax this and to send us the actual written instruction as regards the status of this matter. When can you come?
Lordship, kindly keep it tomorrow or day after tomorrow.
On Monday, next Monday.
Great.
Actually, my lord, the confusion is for this. The petitioner is same. The
Yes, yes, we have enough. To answer the
Grateful, Lordship.
Same heading.
My lord, Mr. Shubir Banerjee appearing for the petitioner, he is suffering high fever. Kindly make note this week.
Next Tuesday করে দাও। আজকে মঙ্গলবার তো।
Lord, item number 3, Mr. Mukherjee has handed over the affidavit in opposition to us on Friday. My lord, I was not well during the weekend. My lord, kindly gives us 3 days. My lord, we'll come back with the reply.
This is which matter?
My lord, this is a pensionary benefit matter in which already a sum was deducted from me from the gratuity, and I had claimed that the full pensionary benefits was not given to me, since one of the respondents has claimed that in the last promotion that was given to me was a lateral promotion and not a promotion, and hence the pay fixation would not be given to me. That is the issue. My lord,
How can you improve that, sir?
my lord, just because some amendments have been taken by them, I
So
only.
it was a lateral entry and there was no difference in scale. So from the
My lord,
date you are-
I will show, my lord, there are judgments, my lord, which says only because of the promotion does not mean only difference of scale, where the responsibilities
No,
are
no,
different.
not. You are right.
Yes.
You are right. But the thing is, that is an issue to be urged for alteration of the pay scale. That is not the challenge here.
Yeah.
You were not given the higher financial benefit on a particular reasoning, which appears to be all right because there was lateral entry. We
No,
don't think, Mr.
My lord, let me come back with the affidavit, my lord, kindly. I'll just.
Mr. Mukherjee, the learned AGP, appearing for the state, files the affidavit in opposition. Let the same be kept on record. Stop. A copy of the same has already been handed over to Mr. Paul, learned advocate, appearing for the petitioner. Stop. When it was given?
My lord, Friday evening.
last Friday, and he prays for extension of time to file the affidavit in reply. So, let such affidavit in reply be filed within 2 weeks from date with a copy to Mr. Mukherjee. Please the matter for further consideration under the heading returnable or key heading motion returnable in the daily supplementary list of this court 3 weeks hence. Yes. Motion. Your heading just-
চারটাতে শোনানো four and item number 4 and 11 may be taken up together, your lordship. Challenging the same order. Item number 11 is a writ petition by the state and your lordship, the affidavit of service of item number 11.
11 এর ফাইলটাও বের করে
এগারো তে আছে।
আমরা ওইটাতে কত আছে দেখ সেভাবে লেখ
ছিল, আর কিছু ছিল না।
both the writ petitions have been filed challenging the same order. Both the writ petitions have been filed challenging the same order dated 25th April 2024. Passed way 534 of 2019. As such, with the consent of parties, both the writ petitions are taken up for analogous hearing. Yes.
না না এখনই হবে what is this my evidence sir what is this my evidence
Item number
Petition ওপরে affidavit of service, as filed, be kept on record. First title টা দুটো দিলাম।
An application for compassionate appointment. Father died 2017. Mother applied. I, being the elder son, also applied. Mother and 2 sons. Mother said,
Show us that you went away from the family
no.
prior after the death. Show us any document.
I was within the family.
না না
no
Kindly come, Mr. Kindly come to page
kindly see page
91.
of our application states application affidavit affirmed by
91. This finding is perverse.
Why?
no finding this is an affidavit
Let me, at least it is my application.
Yes.
But kindly, prior to that, kindly come to the composition at the time of releasing the pensionary benefit. If I am,
No doubt.
That is right.
Your contention is that you are a part of the family. Your brother should not be given. You should be given.
yes,
Government is refusing you because of the reason that you were not a part of the family at the time of death, and as such you are not dependent upon the income of the deceased.
that is there. That is why I am coming to page 40.
40.
40. After the death, the government order for payment of the part of the pensionary benefit share,
So, Mr. Bishas, tell us, when did the death occur?
death,
When was the death?
I have annexed that prior to page 39. Death occurred 24th of April 2017.
24th April 2007. And at that time, were you residing with the family members?
Yes.
Who was something?
That document itself, that page 40.
No.
Because unless I am within the family, that I could not have got this share itself.
No,
I-
no, this year you would have.
Yes. Now,
There's no problem.
the authority, page 91, decided one way, not of my application, nothing has been done.
91.
And that too, the private respondent, being the brother, has made a fraud before the authority concerned. He made in the application that he is class 8 pass. But fact remains, from the school authority, the certificate has been given that he has not passed the class
So
8.
we are not concerned with that. We
On
are
the-
concerned with your dismissal reasoning given.
Reasoning on the basis of page 91. 91 kindly sees.
Yes, read.
Only on the basis of his application, this has been done. And in that case, I did, let us read.
In the inquiry committee, please read.
And
Family consists of
inquiry made, and she lives with the younger son of her home, mud house, such and such. Majina Bibi and Rabiul Haq has no other income in respect of that. And they have said,
no, first paragraph.
first paragraph.
In terms, inquiry committee physically inquired. His family consists of such and such. Among them, the elder son lives separately with the family, and the younger son. Huh?
Where is this finding from? Because I did not have any access to meet with that authority itself. Inquiry should have been made prior notice to me also. If such inquiry is made
Then you
beyond,
will come over from your native
that
place and
that
join.
cannot be done. Since I also made an application, I could have been called on for such in before the inquiry committee itself.
Tell us
Now-
what is mother's declaration. Where did mother say?
It's 26 of our opposition.
Opposition, I feel.
Our disposition.
ওই declaration টা বের
WPST
করে
Act
দেবে?
number 150 of 2024.
Page 92 also declaration is there. I have
One
also
of the
an-
son are eligible.
and I shall
Page 26 is the affidavit of the mother.
Mother. Paragraph 5 and 6.
This is on 12 December 2017.
Yes.
Date was
I
24th
have no
April
relation with
2017.
Sheikh Firoj that did not take any responsibility of mine the last few and so he and is present. If this is said by the mother claiming to be the
No,
dependent.
wait. Page 26. When was it affirmed?
12 December 2017.
Well,
Along with the application for completion appointment, he said affidavit was filed for the younger son.
now the date was in April 2017, no?
25th of April.
24th April 2017.
See, এই কথাটা মা বলেছে আর inspection inspection হয়েছে 6 বছর পরে জুলাই।
Check out of the product.
না, সেটাই বলছি।
Yes, Mr. Vishas, what do
Now,
you want to say?
Yes, now rule, I shall come to the rule itself. Now, if your lordship kindly come to the authority, the school authority was called
No, that aspect,
Munib, in respect of the Munib, I am
whether at all he is eligible or not,
not. That will
that
be
is
considered.
within their domain. We will hear Mr.
My lord, my lord, my lord.
That point will be taken care of by the authorities because authorities have not been directed give appointment.
Court, learned tribunal said, give appointment.
Tribunal said consider in the light of.
No, give appointment.
Give appointment.
Give appointment.
Appointment.
In my petition,
That's why you
tribunal has said give appointment to private respondent. At page 118. Last paragraph. Now, my lord, kindly come to page 99.
to approve the
Mr. Mukherjee, we will hear you. We will hear you, Mr. Why you are so impatient?
No, no,
Take
no.
your seat.
Kindly come to page 99 itself. The school authority said, upon inquiry, that he has not passed from that particular school. So therefore, he is not eligible at all. And the inquiry committee, page 99, must approve his consideration without and kindly come to again page 91.
Class 8 is not entitled to compulsory appointment.
Passed. It should have been passed.
Even if he is not class 8, my lord, I shall show the rules.
All right. Passed.
Moreover, my lord,
Yes.
these report
What
says
has
that there is no
stated
record.
application in his pro forma application as his educational qualification?
8 pass. 8
He
pass.
passed.
I have
Rule
stated
said,
8 pass.
advertisement, I have annexed the rule itself, my lord. Now, he made a submission, page 87, kindly sees. His pro forma for application for getting compassionate appointment, Munib. Column number 2D.
2B,
2D.
D,
Yes, page 87,
past,
2D,
past class A.
past 8. And that is why the government made an FIR against him for giving false statement. He was arrested. Yes.
Where do you find that?
My lord, it is the application of Mr. Mukherjee. Subsequent, I have got this.
Page 87 of my application,
No.
sorry.
Yes.
Application of,
Subsequent to the order passed by the tribunal, my lord, FIR was lodged and I have obtained bail. My lord, I shall face the trial. I will come.
For giving false declaration to the authority concerned at page 66.
Page 66 of order.
66 of
Of
Of order.
their application. For giving this false declaration before the authority concerned.
show us that you were with the family when the father died.
Yes, now definition. Well, I am staying with this particular house itself.
Then
but
why
I,
the mother will say that
I do not know. That rule does not provide that.
you
on
are
the
having a
basis-
family, na?
Yes, I am.
So where are you staying?
I am
Show
staying
in
with
the
that
detail-
particular.
Show your original application where you have stated.
In the cause title itself, residing at Patna post office such and such, police station such and such. If I, my lord,
Page.
no, in the first page, cause title. I am reading from the cause title.
No, show your avardment, na?
Averment. Internal page 4. C onwards, my lord, I have stated
C.
C. Internal page 4 of
There is
my
no C here. Oh, facts of the case.
facts of the case I have stated, and
Where, which paragraph you have stated? You have not stated anywhere.
your lordship kindly come to my application at page 41 itself. That has not been considered till
So you have not stated in the application. Where are you staying? Whether you are staying with the mother or not. That is not there. Oh, very good. Now then page 91. Page 91.
no page 41. It is my application before the authority for getting compassionate appointment.
very good. Hold on.
I have stated that my father is there.
Hey, Mr.
No, I
Vikas,
got
why
this point.
you are a learned member?
I
You show
got
us where is that line that I am deciding with my mother? Anywhere you show us.
Oh, after
You show us that after death I went away. On the date of death I was with
there is specific government is required to be done. Your
you.
lordship.
That the entire
No.
case stands on that and you are saying করতে হবে।
Even then, not subject to correction. But I know this.
তাহলে
But kindly come to the rule itself. There does not say ওখানে কোনো statement আমার বলা নেই। যা কথা ওইটাই বলা আছে।
Maybe. Page 100 দেখো তুমি তো নেই আমি চেক করি ওইটাই তো হুম হুম এবার কিছু নেই ওই গ্যাপটা আছে অলরেডি ডেট অফ ডেথ হচ্ছে থাকতে হবে তবেই সে ডিপেন্ডেন্ট হবে এই কথাটা তো এই জন্য নো অবজেকশন আচ্ছা সৌদীপ your where is your pro forma application where is your pro forma application
My lord,
page
that is at, my lord, page 58.
58, 59.
page 59 loss for
My lord, there is a provision for no objection.
এখানে সেপারেটলি loss for that
58.
it's a
59.
dependence term so we have to explain how it actually is dependent এটা স্কিমের সেটা তুমি স্কিমে কোথায় আছে দেখেন হ্যাঁ না যে হি হ্যাজ টু বি এই ক্লসটা যেটা আপনার একদম আমি দেখবেন পেন্ডেন্ট
And my lord, there is a provision for no objection.
My lord, now,
Lordship will kindly take care of it.
if your lordship kindly come to the rule itself, I have annexed.
হ্যাঁ
Maybe he is
this dependent term has not been defined
dependent.
বলো এক্সক্লুশনটা
It means
তো তুমি বসো সেটা বসাচ্ছ অলরেডি
My lord, kindly come to page 100. This is the rule. Whether I shall be staying separately or not, or declaration to that effect that my mother declared that I did not stay with her in that family. Nothing as on this date, that rule itself. I shall go by the rule itself. My lord, kindly come to page 100. EMP 251. Definition clause, dependent family members there. Now, 101, eligibility criteria, column number 6.
হুম
Now, kindly come to stateway. After 6, I am reading column number 13, 11. If I get the appointment upon consideration,
Undertaking.
column number 11. Only undertaking part is there. That I have to maintain my family after getting appointment. And there is no such provision that no objection in the rule itself from each and every member for getting such appointment and to declaration to that effect of the mother in this case, that if somebody is staying separately, in this rule I do not find this. Now, consequence there of page 109. Amendment of this rule for the purpose of issuing appointment on compassionate ground on the Group D employee, column number 6. My lord, got it. Now, may I read for your lordship? The candidate applying for different category of Group D post shall have class 8 pass. Clause 6 at page 109. It starts, that notification starts from 108, and vital point is qualification.
No, that we will hear. We wanted a
For that reason, now there is no concession at all.
That is a Group D recruitment rules, not compassionate appointment scheme. It's a Group D recruitment rules.
You are also married. You
Yes.
are also married. Very good.
So in
Yes.
this consonance, my lord, if his application, first thing, my application has not been considered at all in the touchstone of page 91. Till pending.
Page
Page 91, that inquiry officer's report, or authority's report, does not speak about my application itself. Whether my application will be untouched for giving, not to give appointment of my case. This is the first issue, my lord, subject to correction. Tribunal held that I am not entitled separately, but without considering my case by the authority itself. Goes further.
what they will consider. This is
Either-
not a case. This is not a case that opportunity of hearing has to be granted.
Has to be granted, but my application, the
That-
date
that
of my
has-
application.
No, inquiry of committee can conduct an inquiry only upon giving notice to all members.
Member, that
Where
notice,
is that provision?
that no notice was given to me
No
also.
notice is required also.
And that
Come to
finding
this
itself
scheme.
says that on the basis of application made by Muni itself.
Maybe, but you use the jurisdiction of the inquiry committee.
And
you will
if that
find
is so,
that,
if
you
that,
will find
page
that in
91,
the
page
scheme.
91. Can you
Now,
see?
kindly come to page 104.
104,
Have you annexed the annexure A and B
A and B of,
of a 251? You have not annexed.
pro
The
forma.
procedure says that application has to be submitted as per annexure A and B.
Yes.
Annexure A says that no objection from other candidate is required. Now you can say that annexure is not the part of rule. If you say, rule says, this calm procedure
Hmm.
to be followed. 10B,
Hmm.
application is to be submitted as per the prescribed format. That means annexure A or B. Annexure A or B requires that no objection is to be obtained from the other legal heirs or dependent family member.
Yes.
So bring that annexure.
Don't say annexure to page 59.
Is 59. Page 59.
Close.
So here, other dependents of the member. If this annexure required,
But he did, the authority even did not.
hence, no objection, they enforce.
Yes, Mr. Mukherjee, what is your contention?
Wanna kindly see our declaration WPST number 150 of 2024.
100 and
150 of 2024. State versus
yes,
Firoj.
yes, what you are showing?
Wanna kindly see the order passed by page 26 of Y declaration.
ওই ফাইলটা দিয়েছো ওনাকে?
Paragraph 5 and 6. I have no relation with the Sheikh Firoj. Have you also got it?
Page?
Page 26.
You are showing us the order.
No, I'm showing the affidavit filed by the mother.
Page 26.
Page 26.
You have showed us.
Paragraph 5. That I have no relation with him, Sheikh Firoj, that Sheikh Firoj did not take any responsibility of the mine in the past and is in present. Monija Bibi, mother of the Mr. Bishop's client. Then your lordship will condition in the application, that is at page 30. Page 30. For a moment. Column number 2, small d, educational qualification, 8 passed.
Yes.
Both the applications filed by some business clients and Mr. Roy's clients were processed.
No, his application was not a pro forma application.
No. But then
Firoj had no pro forma application.
then
Pro
page
forma
37 for a moment.
page 37.
Yeah. Manija Bibi, wife of late Rabiul, has no other income except family pension for predecessor Sheikh Firoj, who lives separately, works as tailor 2,000 per month, and the younger son Majid, who works daily as labor, earns rupees 20,000 per certificate and Aranpur Campus, along with the affidavit. She has much difficulty with it. Then, hence, the inquiry committee recommends for suitable employment of Shaykh Midaj, son of Sasaj, recommended by his mother. The sisters through court affidavit in order to get family mental relief distress condition. However, the elder son, Sheikh Firoj, has refused to give his no objection in favor of the fellow to give employment. Then you will have to be done. See? Then,
No, what did you say?
no, that no objection certificate has not been given by Firoj.
Hence, the inquiry recommends for suitable employment of Mojid, as recommended by his masters, mother and sisters through court affidavit in order to get rid of her family from mental. However, the elder son has refused to give no objection.
But then, so far as Mr. Rai's clients is concerned, we have sent a file for police verification.
You have sent?
The file for police verification.
Achha, you send it for police verification after this inquiry report.
Inquiry.
Achha.
Page 51.
Page 51.
Yes. Subject, appointment and compulsion of Sheikh Mujib, son of late Rabiul Haq, ex in response to the above, I am to inform you that police verification role of Sheikh Mujib, son of late Rabiul Haq, ex Mazdoor, was sent to the Superintendent of Police DIB Purva Bardhaman for verification of antecedents. Sheikh Mujib for appointment compulsion down. But the same has been received with the comments of DIB that education and qualification of Sheikh Mujib is class A7 plus. A copy of the PBR is attached to it, temperature, though the matter of appointment of British, then now necessary access mean the above matter is certificate. Then page 53. We write to the school. Page 53. 3rd of May 2023. Have you lots got it? Page 53.
Page 53.
Yeah.
No, where is the
After
where
that,
is the police verification?
Come to page 54.
54 is the
54.
54 is the reply.
54 is the reply.
Yes, see,
I beg
he
to
had
say
read
that
up to class 8 but couldn't pass.
there is no record of readmission of class 8 in the next session. 2020, the date of birth record in the administrative insurance serial number 10, 67, number 18.
We file an affidavit. You reply. It's 55.
If he does not have the requisite qualification under the rules, can it be appointed? And the tribunal directed to appoint him.
You have the power to relax.
What of kindly see? Recruitment rules, kindly see. Recruitment rules.
Page earlier, page 100.
You have filed and replied before the tribunals.
102, come to earlier repetition, 102. Now, whether you will exercise such power or not, it is your domain. Right?
last, no, 102, অন্য petition, last question.
But if somebody made representation, FIR has been filed. But can the relaxation be exercised?
Representation. We had
And relaxation only for age, relaxation only for age. Age.
No, no.
Trying to- Relaxation in educational qualification may be granted in eligible cases.
Educational
Eligible
qualification. Educational qualification.
Eligible cases. Well, if somebody commits a fraud upon the department, he is entitled to relaxation.
Why didn't you tell this to the tribunal?
we filed a
So many
File a reply.
page 60,
Page 60, page 60,
page 55 to be through, page 60.
60, paragraph 6, page 59.
Upon notice, report was received, inspector.
Paragraph 3, sir, some paragraph. In the meantime, police verification
Paragraph?
report was received.
where you are reading?
59, 59. The words, which the sentence was starts with, upon having notice of the order of the Honorable Calcutta High Court, further processing the prayer of compulsion appointment was stopped. In the meantime, police verification report was received in respect of Mujib. It means that the declaration given by Sheikh Mujib that regarding education pursuit is false. Sheikh Mujib claims to have class 8, whereas as per TBR, he has been passed class 7.
No
It has
repetition,
subsequently
repetition,
been confirmed to be a letter dated 5th June 23 by the headmaster of 500.
no, no.
Then Firoz, can't say about Firoz, paragraph 5. Sheikh Firoz subsequently application in the prescribed form was submitted by Sheikh Mujib on 33rd January 2018. Provisions of joint plain paper has been deleted by notification dated 1st March 2016 of the Labour Department, Government of West Bengal, as per clause 10A of the notification dated 3rd December 2013. The application for appointment is submitted within 6 months from the date of the retirement of the permanent incapacity. If no application is received within the said period, it will presume that family does not require a measure. In case no application submitted,
So that you ought to have taken before referring it to the inquiry committee. His objection does not survive. Your inquiry committee embarked upon
from
the case.
1st March 2016, plain paper application is has
You
been.
cannot go into that, Mr. Mukherjee. Now the issue is your inquiry committee has recommended.
Yes.
You have taken follow-up steps.
Yes.
Upon taking follow-up steps, you have ascertained that there is a practicing of fraud allegedly. This is your argument.
And mother tribunal cannot direct to give appointment without having the requisite qualification or police verification is correct or not. Before the tribunal, everything was disclosed. How the tribunal can pass an order? And the recommendation is subject to police verification and qualification of the candidate and medical exemption.
Where is that in the scheme?
Mother,
In the scheme, where is that? That medical.
Mother, scheme says under which ground appointment of compulsion should be given. But he must be a citizen of India and must be age of above 18 years. And if it is not written for a moment, can anybody appoint it? Because there will be the agreement, statutory agreement between the parties.
Now you have lodged a complaint, police.
FIR has been.
FIR has been lodged and he got a bill from the Senate.
He got bail. Yes,
So my humble submission is, my lord, this FIR is an afterthought. After the order was passed by the tribunal, your lordship will find
we are
that this.
not stopped.
No, I cannot say that. Now, only thing, my lord, so far as the first writ petition is concerned, about my elder brother. My lord, that writ petition is not maintainable despite being the elder son. My lord, since my lord, the dependent family members, first comes the spouse, that is the wife, and the sons will come. Now, no objection, as my lord, this honorable court has just now observed, my lord. No objection has not been given, and there is a specific finding of the this committee upon physical inquiry that he is not residing with the mother and not taking care of the family.
Is applicable.
My lord, undertook
How do you overcome
How
this
do you overcome?
verification?
verification, my lord, verification. So far as the pendency of the criminal case is concerned, my lord, at this stage, my lord, I can only say, my lord, that let this recommendation be abide by the result, because I will
No.
face the trial. No, I will face the trial. I have no other option. If an allegation, if allegation may be,
Succeed, you approach.
yeah, no, approach,
Succeed,
they have already recommended. Thereafter,
that recommendation has to be confirmed by the appointing authority
Yes.
under that scheme.
now, my lord, the recommendation at the present, my lord, they are not confirming, because their specific case is that my 8-pass certificate is
Yes.
false.
So if you are acquitted in the proceeding, then
Then,
the
my lord,
question-
automatically this recommendation
No, no, no.
stands.
No, that is not.
Because otherwise,
We are recommending.
it's a recommendation, but upon inquiry
upon inquiry in 2018.
in 2018, but
but in
regarding the
2020
financial distress and all things, my lord,
yeah, we have survived 2024. We would have directed them to give you appointment.
my lordship.
But in this view, how can we
Now,
affirm?
if your lordship will find, if your lordship sees, my lord, although, my lord, we cannot go into the merits, they says that the records in the school are not found. Records are not found. These are,
They made it.
yes.
How
It
can
cannot be
we-
said that
You are
I
not
have,
having a clean sheet.
no.
First argument of his UK tribunal cannot directly say give appointment. That is his argument. Even if we do not accept such contention, how can we direct you to be granted appointment when there is admittedly on face of records criminal proceeding is pending?
Criminal proceeding is pending. I am not asking for an appointment, my lord, today.
Yes.
My lord, they after, my lord, after the completion
After
of the
proceeding ends,
after-
there will be no immediacy.
Immediacy.
You would
No,
have supplied.
may I submit in this way?
Yes, you will lose.
No, compassionate appointment, the scheme of compassionate appointment, your lordship knows.
Endless compassion cannot be given.
No, my lord, may I put it in this way? May I put it in this way? Since, my lord, this scheme, my lord, postulates that this scheme is beneficial scheme only to meet up the immediate urgency. Now, my lord, there is a recommendation. I didn't get the appointment. The recommendation by the state themselves. Subsequently, when my elder brother, my lord, he could not succeed, then, my lord, the records are not found in the school. I cannot put
Your conduct. We are a REIT court.
lordship.
We have to take into
I understand.
consideration your conduct.
Lordship.
You could have said at the time of application, I have not passed class.
No, I am 8 pass. I am sticking to that.
So you have to establish
If I
that.
say that I am not 8 pass, then I have no case at all.
You have to establish
Because my false declaration itself is a ground for rejection of my case. I'm
None of you are
candidly
fit
submitted
for
on that.
compassion.
But my
None
case
of
is
you are fit for compassion.
No, no.
no, my lord, my case is, my lord, your lordship will kindly indicate to that
reply,
extent.
2-minute reply. 2-minute reply. Page 27. Kindly come. 2-minute reply. There are pages will dictate.
Page 20.
Page 27 in the application, but I have stated in the limitation part, page 4, that my application was not considered. Even then, there is no rejection order.
Page
Page 27 of my application.
What you are saying?
I'm saying that my application for compassionate appointment is not considered, even then no rejection order on my application itself.
It was not in form.
That should have been said. Yeah, I did not make any application in proper form, therefore my application could have been rejected. That order also not coming from elsewhere. Now, second thing is page 65. I have denied that allegation in
No,
my.
we didn't understand. Page 27, what you are saying?
I'm saying that my application for compassionate appointment neither reject nor considered nor even not rejected at all, even on the ground that my application without any pro forma could have been rejected. That order should have been passed, and my application is not in proper form, therefore my application is rejected at the threshold. They have not done or considered at all. And page 65 I have denied to that extent that I have a good relationship with my family. Even an affidavit.
There is an unrebutted statement of the mother. I am not
please.
insisting on my statement. My the mother gave a statement which he could not.
So far as my
He is
declaration
speaking
part
about
of
undertaking.
no objection part is concerned.
Page 67.
65. Paragraph 5 I have denied to that extent before the tribunal itself.
Denial will not do.
Now, third, yes.
Then mother should have been cross-examined. Mother should have been cross-examined.
Third point regarding no objection part is concerned. If that is mandatory, then I did not give no objection to the authority regarding getting appointment. That does not reflect.
You didn't give no objection to Modi also.
Yes.
Either
Respondent number 5 could not have
Either of you
page
object.
9.
No objection.
My lord will only keep
Not
that
the
opening for
mandatory
me
one.
because
Mandatory one is undertaking page paragraph rule 11 that after getting appointment, one of the family members, he will look after the family itself. That is the finding. Rule kindly come to page 101. 102 itself. That is the 105. 105. Only that is the mandate. After getting appointment, I have to look after my family. Even when one family member does not give the
that undertaking
that is, not
is qualified by the no objection.
Maybe in the
Mother didn't give him no objection.
the present petition.
And order 41, rule 33, in adversarial litigation, private respondent cannot be appointed in terms of the order of this tribunal. Operative part, they could have made application before the cross objection or cross appeal or cross application before the authority concerned.
Mr. Vishwas Lanet
Grateful
appearing for the petitioner in WPST 106 of 2024. Comma, namely, comma. ওটা কি বাঁধা হয়েছে গো? namely, Sheikh Firoz, bracketed in short Firoz, submits that the learned tribunal Mr. Vishwas Learned submits that under the scheme for appointment on compensation ground, ওই স্কিমটা ওখানে আছে, কমা 2013 ব্র্যাকেটে in short said scheme. An incumbent can be considered for compassionate appointment subject to grant of an undertaking that he would be looking after the other members of the family. The Firoz is ready and willing to give such undertaking. And as such, his application not require any further grant of no objection by his brother, namely Sheikh Mujib, MUZI, bracketed in short Mujib. Such argument as advanced was not considered by the learned tribunal. He further argues the fact that he is living separately with his family and was not dependent upon the income of the deceased has not been established by the inquiry committee upon granting an opportunity of hearing to him. In view thereof, the report of the inquiry committee ought not to have been granted any weightage by the learned tribunal while rejecting Firoz's claim. A private association appears to seek a to approve the employment of Mujib on compassionate ground, subject to an undertaking under this scheme. Such direction is not sustainable. Such direction is thus not sustainable. Mr. Mukherjee learned AGP appearing for the state respondents. AGP appearing for the state respondents, comma, who are the petitioners in WPST 150 of 2024 submits that the ordered impute suffers from a jurisdictional error, inasmuch as the learned tribunal could not have passed any specific mandate upon the respondents to approve the employment of Mujib on compassionate ground. He further argues that the learned tribunal passed the impugned order, being oblivious of the fact that in course of consideration of the petitioner's claim, while considering being oblivious of the fact that on the basis of the inquiry report, follow-up steps were taken by the authority, and the petitioners and Mujib's application was sent for police verification. And it was found that upon police verification and upon investigation, it was ascertained that Mujib has not passed class 8. Accordingly, for furnishing false information, a specific complaint was lodged and the same was registered as FIR number 529 of 2024, dated 14 June 2024. In view of thus Mujib has suppressed material facts, and such conduct itself disentitles him from grant of compassionate appointment. So the learned advocate appearing for Mujib submits that Firoz was not dependent upon the deceased, inasmuch as he was residing separately along with his wife and children. Prior to the death of the deceased, he was in no manner such as would be explicit from the declaration submitted by the mother, and also from the report of the inquiry committee. In view thereof, Firoz does not fulfill the requisite qualification for grant to be considered for grant of compassionate appointment. And as such, he made a frantic attempt to restrain the state authorities from considering Mujib's claim for compassionate appointment. Stop. As he was not dependent upon the income of the deceased, the learned tribunal rightly did not exercise any discretion in favor of Firoz. He further argues that the Mujib's claim stands fortified by the inquiry committee on the basis of the inquiry conducted in consonance with the scheme. And as such, the respondents are bound to comply with such recommendation as furnished. So, answering our query, he submits that a criminal complaint had been lodged against Mujib, alleging that he had wrongly wrongly states his educational qualification to be class 8 pass. Stop. He was arrested in connection with the said proceeding, however, he subsequently obtained bail. According to him, next paragraph, according to him, the learned tribunal, placing reliance upon the inquiry report and determining that the family was in extreme financial distress, rightly recommended Mujid's claim, and there is no infirmity in the said order warranting interference in the writ petition. We have heard the learned advocates appearing for the respective parties and considered the materials on record. Stop. Indisputably, considered the materials on record. Stop. Records reveal that initially the writ petition, initially the application, the ONM initially challenging an order dated 6 May 2022, passed initially by the learned tribunal in Mujid's application being OA 534 of 2019. A writ petition was preferred by Firoz. And the same upon contested hearing was disposed of by an order dated 9th of February 2023. Setting aside the order impugned and directing the learned tribunal to consider and dispose of the tribunal application. Pursuant to such direction, the learned tribunal heard the original application afresh and disposed of the same by the order impugned in the present writ petitions. Stop. The learned tribunal has rejected Firoz's claim upon arriving at a finding that Firoz was not dependent upon the income of the deceased, and that he was separately residing, and he was residing separately, and that he was residing separately, as would be explicit from the mother's declaration as well as the contents of the inquiry committee report. We do not find any infirmity in such direction of the learned tribe. Stop. As regards consideration of the claim for Mujid is concerned, we are of the opinion that the learned tribunal ought not to have directed the respondents to, ought not to have issued any mandate upon the respondents to approve the appointment of Mujid on compassionate ground. Such mandate prevents the appropriate authority from conducting police verification for completion of police verification and other formalities prior to grant of such compassionate appointment. In course of police verification, it was ascertained that the petitioner that Mujid has wrongly declared his educational qualification to be class 8 pass. And on the basis of this, and accordingly, a police complaint was registered in connection with which Mujid's claim was, Mujid was even arrested. Thus, there is a serious dispute existing as regards the fulfillment of eligibility criteria by Mujid. Stop. Learned advocate appearing for the private respondent submits that under the scheme itself, the respondents have been conferred the jurisdiction to consider the issue of relaxation of educational qualification. We, however, are not inclined to accept such contention, since the very fact of suppression of material, since an erroneous statement was made by Mujib as regards his educational qualification. Stop. The direction of the learned tribunal as such to approve the employment of the approve a compassionate employment of Mujib is thus not sustainable in law.
My lord, erroneous statement is disputed, my lord.
Hmm?
The erroneous statement has been made, that is falling from your lordship's, my lord. That is the allegation. I'm facing the criminal trial. My lord, I said that, my lord, kindly, my lord.
Yeah, just.
Lordship.
They allegedly
Great.
an alleged erroneous statement in the said conspectus we are of the opinion that the learned tribunal ought not to have directed the authorities to approve the employment of Mujib on compassionate grounds. Stop. More so, stop. Neither Firoz nor Mujib, in our opinion, is entitled to compassionate appointment. Is not entitled to compassionate appointment in consideration of the settled proposition of law that compassionate appointment is not a vested right, and more so, such compassion cannot be endless. In the facts, compassionate cannot be endless. The family of the deceased has survived for a substantial period of time, and the issue of immediacy is not fulfilled in the facts and circumstances of the case, warranting appropriate direction upon the respondents to grant compassionate appointment. Employment assistance to either of the sons.
My lord,
of the
regarding this
deceased,
immediacy, my lord,
namely,
my lord, there was a recommendation in my favor. There are, your lordship knows, my lord, authorities, my lord, when the matters are pending before the court, my lord,
the writ petition,
my lord, my criminal, my lord, some opening.
petition of Firoz, the writ petition of Firoz being WPC ST number such and such is dismissed.
My lord, so far
And
as
the
my,
writ petition preferred by the state respondents being WPST number.
my lord, some opening may be kept, my lord, to my fate, my lord. Your lordship was with the view, my lord, that if you are acquitted in criminal case, because my case was, my lord, I was recommended, everything was over. Now this false allegation, my lord, if I am to suffer and the entire family, and my lord, immediacy, my lord, your lordship, my lord, I need not.
What can be done at this stage? We cannot
No,
say.
I am not at this stage. I am not asking for, my lord. If your lordship has made the my lord observation that there is no immediacy. If that is gone, then my lord, my acquittal doesn't matter. Then everything goes, my lord. My lord, your lordship knows, my lord, pendency of the cases, my lord. These is so many, my lord, compassionate appointment cases, my lord. If there is no fault on the part of the applicants, my lord, they are not to be prejudiced. My lord, only one.
Needless to observe,
Because, my lord,
in the event Mujib is acquitted in the criminal proceedings, and the state authority and the state authorities and the is acquitted in the and if he fulfills the
grateful, my lord.
and
Only
if he
this one.
fulfills the eligibility criteria, and if the sense of immediacy remains,
Yeah.
comma, the respondents would, the respondents.
My lord, I bowed down before you.
Mujid may approach the respondents for consideration of his claim and approach.
I bow down.
Okay, 3 hurdles, you cross.
Because, my lord, grateful, my lord, deeply obliged.
Yes, next.
I am for the petitioner.
পাঁচ হচ্ছে I'm for the petitioner, my lord.
Yes, Mr.
My lord, order is the last annexure, is the order of the learned tribunal. Last annexure, my lord.
It is fixed on November, Mr. Newby.
My lord,
Your matter has been fixed on November 24th.
provided that if there is any judicial member,
Oh, I
the
see.
judicial member will never come. It is pending for 2 years. There is no judicial member.
What
I
interim
paid for
order?
interim order. I tell you, Lordship, what has happened? My client is a revenue officer. My lord, in the month of March 2013, he was informed that his office will be inspected by the inspecting team. My lord, on 30th, inspecting team came and took away the official documents without making the scissor list, without making any receipt. And they told me that they will come again on 2nd or 3rd April. On that day, they will return it. They have never come. I made an application before the revenue of BLRO that such and such thing happened. They have come, they have taken out the document. I made an application, they annexed it, my lord. On 8th, I have been suspended from service.
8th of
8th of April.
8 May.
8th of May, I have been suspended from service. And my lord, on 15th of May, charge sheet was issued on the allegation that I could not produce the documents.
15th of May.
My lord,
Which year? 15th May?
2013, my lord.
15th of
My lord,
Charge sheet was-
that charge sheet goes because
wait.
8/8/2014 charge sheet.
When was the charge sheet issued?
my lord, charge sheet is 2nd April 2022.
Arey,
That charge sheet
Madam,
is
let
no
me-
more there.
Wait, Mr. Mukherjee, very difficult to control you. Very difficult.
8/8/2014.
My lord, 8/8/2014, a charge sheet was issued.
8/8/2014.
A charge sheet was issued.
You were suspended on 8th May 2013.
13,
Charge sheet was on 8th August 2014.
14.
Very good.
And my lord, that charge sheet was revoked by the governor order in the month of May 2015. But I was not allowed to join.
Ja. May 2015, it was
Suspension
revoked,
order was revoked.
that charge sheet.
Charge sheet, suspension order. Suspension order was revoked.
Huh? Not the charge.
No, not the charge sheet. Suspension order was revoked.
Suspension revoked. You were allowed to join.
No, my lord. I reported twice to join the service. After revocation of the order of suspension, my lord, I am not allowed to join. In 2017, I filed an original application. There, the respondents make an incorrect statement that I did not
What?
report for
You
duty.
preferred an original application claiming what?
My lord,
Joining.
for joining, for not allowing me to join even after revocation of the order of suspension.
Very good. Then what did the tribunal say?
My lord,
30.
and my lord, in that application, this affirm an affidavit stating that I have not reported for duty. I have annexed the document that I twice reported for duty in the month in month 2015. After that, my lord, that since the charge sheet was challenged by me, that charge sheet was a draft charge sheet. My lord, on 31/3/2022, the respondents submitted before the learned tribunal that they do not want to proceed with the charge sheet.
In that original application,
Original application.
which you preferred.
In my original application. When came up for hearing, they submitted that they would not, kindly see the order.
Then what happened? Tell us, Mr.
Page 162, kindly see, my lord, that's 162.
So they said that we won't proceed with that.
They will not proceed with the charge sheet.
Huh.
They create liberty from the tribunal to issue a fresh charge sheet.
but no liberty was granted. After 15 or 16 days, they issued the same charge sheet. That was the challenge before the learned tribunal. Same charge sheet. On, my lord, on 22/4/2022. That has been challenged before the learned tribunal.
Have
Learned
you,
tribunal
in
admitted
connection of the new charge sheet, have you been issued any fresh order of suspension?
no suspension. Only charge sheet on same set of facts.
So you have still not joined. You
I
have
have
not.
I have joined.
You
I
have
was
joined
allowed to join in 2017.
by virtue of original application.
16/5/2017, I was allowed to join.
You preferred the original application saying I am not being allowed to join.
Yes,
Yeah.
that was disposed of. I was allowed to join in
I was
2000
allowed to join.
That was disposed of.
That was disposed of.
When?
That was disposed of. That was
2017. 2017.
4/2017.
Page 30.
Page
Page-
158.
Page
30.
page 30, my lord. Page 30.
30.
30.
Very good.
This is the
Now what interim order do you want?
But since my submission is this, when they have
Self-same draft charge sheet has been
issued without the liberty of the court, my submission is this: when they have prayed before the court, they will not proceed with the charge sheet. Whether they can issue the charge sheet without the liberty of the court, when liberty was not granted. That was the subject matter challenge in the second application.
show us that order. Liberty for what? Employer does not require any liberty to proceed against you.
My lord,
Does the authority
your lordship
require
kindly
any-
come to page 162.
152.
Page 162.
163.
Self-same charge sheet.
তারপরে আবার একটা সুপার করেছে 2016
Same draft charge sheet, পুরো আবার fresh charge sheet। দেখছেন? ওইগুলো বন্ধ করতে হবে।
So proceed with the charge sheet. Page 163.
কতদিন হয়ে গেল? সেটা দেখি। আচ্ছা, ফার্স্ট শো আস দি ড্রাফট চার্জ শিট।
Draft charge.
Page 44.
Page 44.
8th
Yes.
August
Page
2014.
44.
Draft charge sheet was 8th of August,
2014.
that is page 44.
44.
And show us page 162, what you are showing.
163.
162, the order.
I will
Yes,
draw the draft charge sheet.
yes, what you are showing.
My lord, your lordship come to the second paragraph.
163.
Page 163.
One 60 here. Yes,
They do not want to proceed with the interim charge sheet, draft charge sheet. HFT.
Your lordship kindly come to paragraph, my lord. However, the departmental representative has submitted that, yes, the applicant did not receive the final order, final copy of the article of charges and statement of imputation of misconduct. Therefore, they do not want to proceed with the
Draft charge sheet.
with the draft charge with the
Draft charge sheet.
with the charge sheet with the draft charge sheet
Dated.
and dated 8/2014 and communication letter dated such and such, and want to give fresh
Chance. to
chance
the-
chance to the applicant by way of issuing a fresh charge sheet. However, the learned counsel applicant has submitted that, so he has nothing to say. If the respondent withdraw the charge sheet, withdraw the impugned charge sheet dated 8/8/2014 and communication letter dated such and such. However, he has vehemently opposed to grant any leave to the applicants to issue a fresh charge sheet
Respondent.
to the respondents. No liberty was granted.
তো সেই চার্জ শিট করে সেখানে একটা সুপার করে
কি লাগে?
আমার মতন একটা সুপার
now when What 144? Where is your first charge sheet?
Page
Draft
44.
charge sheet, page 44.
44.
Page 44 is not telling with us. Where is the charge sheet?
কোথায়? পরে কিছু নেই। কই নেই?
Where is the first? Where is the draft charge sheet? Page 114.
Page 72.
Uh,
72 কিন্তু আমরা 30 এ নয়।
Page 14.
The subsequent most probably.
What? Page
নেই, নেই, নেই।
This is subsequent.
No, I'm saying.
70 page 74.
Your lordship kindly come to page 108. Your lordship come to page 108. 108 is the memorandum and 109 one of the charge sheet. Draft charge sheet.
Draft charge.
Article of charges.
এগুলি ভোট জেলে নেই।
পরে চার্জশিটটা পরে চার্জশিট
very good. Now, where is the new charge sheet issue?
169
Page
74.
No.
No, 177. 169.
Charges are identical.
charges are identical.
The kindly see the language.
Excepting the word draft.
they have
Charges are
admitted,
identical word by word.
they have admitted that
They have admitted that.
They have admitted where?
My lord,
The charges charge sheet is
তাদের রিপোর্টে
হ্যাঁ?
রিপোর্টে ওরা অ্যাডমিট করেছে
my lord, they have concluded the inquiry and they have also issued a show cause notice as to why punishment should not be granted. That's why the matter, that's
those
why,
who have gone.
my lord,
Those have been declared to be infructuous by the tribunal,
yes. After that, my lord, when the
pertaining to the earlier draft charge sheet.
draft charge sheet.
Uh,
And when the second charge sheet was issued, I challenge that during the pendency of that, no matter was admitted, during the pendency of that application, they have completed the inquiry and also issued a show cause notice. That's why I have made an application before the learned tribunal, either to hear the matter or to pass an interim order.
show cause where?
সেকেন্ড প্রপোজ হচ্ছে 180
One,
180
But kindly see the order of the impugn order 866.
180
180.
You participated in the inquiry.
participate
I participate. But
Then,
as
Mr.
so far as the
Niyog-
earlier inquiry is concerned, my lord, I participated in and every day. And I requested them to give a
No,
original
after this charge sheet, did
yes.
you participate in
No.
the? That is what we are asked. Page 180 is relating to the earlier matter.
Yes.
no
Where is after this charge sheet which has been issued in 2022?
Yes. They have.
You
they
have
concluded
preferred an
the-
original application challenging the charge sheet.
Yes.
Show us what interim order you prayed for.
That
Where
matter,
is-
that matter has been admitted by the learned tribunal and directions were given to file reply and rejoinder.
What interim order do you want, Mr. Yogi?
stay on the original application
Now, no stay was granted.
না না আমরা কি চেয়েছিলাম
আমরা we want a stay. We want a stay.
clarification injunction
My lord, page 57.
No.
তারপরে ফোকাস করেছে, তারপর আবার একটা ফোকাস করেছে, 180 পরে আবার একটা ফোকাস করেছে, ওটা তো পানিশমেন্ট অর্ডার। আবার 2024 একই inquiry করতে আবার একটা ফোকাস।
গণেশ পুজো ধাপা পাতো তো ঠিক বললো।
বলছি 2014 না না শোনো 2014 চার্জশিটটা ফর্মাল চার্জশিট করবে
হ্যাঁ এটা
স্কেল চার্জ ঘুরিয়ে দেওয়া উচিত
আবার ওই ইনকোয়ারি করে দিচ্ছে, আবার 24-এ সেম ফোকাস করেছে।
আগেরটাই করেছে ইনকোয়ারি ফোকাস স্টেজ অব্দি হয়ে গেছে কিন্তু দেখো পেজ 160
এটা
It was said that to us. The order has not been challenged.
সেকেন্ড শো করবে সেকেন্ড শো করবে
Even we sales payment, but the charge
এই 70% ড্রাফট চার্জশিটের বেসিসে, তারপর সেটা ওরা উল্টো করে নিল, আবার একটা ফোকাস করে 24-এ আবার একটা ফোকাস করে।
yes, after this, what has happened? After this charge sheet was issued, any further steps were taken.
A second show cause notice was issued. I have replied to that. Now in 2020.
Second show cause notice was issued
I have
after this charge sheet.
after
Yes.
this,
আফটার এনকোয়ারি
after the inquiry.
Inquiry was completed.
During the pendency of that, one of the subject matter of challenge of the second way, whether they can issue a charge sheet on same set of facts without giving liberty from the court. That was the
Okay, that is subject matter of challenge before the learned tribunal.
learned tribunal.
Learned tribunal. Now you are paying for an interim order.
Learned tribunal refused to pass an interim order.
Interim order, yes.
So
We are
also,
on the
also hearing because there is no judicial member.
Now it is at the second show cause stage.
না না না,
So notice has been issued.
180
Second show cause notice has been issued. Where is that, Mr.
In the supplementary affidavit, page 7,
সাপ্লিমেন্টারি এফিডেভিট 2004
7 May 2024.
Our supplementary evidence.
yes
Where is the supplementary?
ও নিজেই পড়ে
this is second show.
Whether this is second show cause notice on the same set of facts.
right, Mr. Niyogi. We
Second show cause notice.
No, it is a second
This is
because
the
notice
second
in respect of the
yes,
yes,
the focus notice pertaining to the charge sheet of 2022.
22.
It's very
This
good.
is second.
So you have on the basis of the new charge sheet.
Yes.
For which liberty was not granted according to you by the tribunal.
yes.
They have proceeded further. They have conducted an inquiry. You have participated. Now second show cause notice has been issued.
Second show cause notice 180. After that, again another show cause
Madam,
notice.
kindly come to page 180. 180.
180 is 2023.
2023 show cause notice.
2023.
Oh, that is prior to the draft charge sheet.
No,
That
no,
has gone.
No. My lord, the second charge sheet was issued on 22nd of March, 22nd of April 2022.
Yes.
And thereafter inquiry was held. And in 23, my lord, second show cause notice was issued. I replied to that. In 24, when the matter is pending, they issued another show cause notice. Challenging that, I have filed a supplementary affidavit. Today I am filing it. Because after filing of this application, they have done so.
In your writ petition, page 170 is the new charge sheet.
Yes.
Page 1, that is of 22nd April 2022. On the basis of that, they have conducted an inquiry. They have issued a second show cause notice
Page
during
180.
pendency of this application.
That is 180, my lord.
Page 180.
180.
Page 180.
180.
Page
But
180.
this
Page
is of
180.
2023.
2030.
It is, my lord, and it is, my lord, 17th of March 2023.
Then what happened?
Then nothing happened. I approached the learned tribunal.
Supplementary evidence.
Yes. After filing of this writ
After
petition,
filing of
again.
this writ petition, they have issued the second show cause notice. That's why to bring it before your lordship, I filed this this supplementary application. Whether they can do so.
Another.
So Mr. Mukherjee, yes, what do you say?
After the
Don't take the final decision without leave of the tribunal. Let the tribunal.
can you see 162 for a moment? 162 for a moment. Order 169. Oh, sorry, 162. Order passed by the London Tribunal.
Yes.
Can you see? The instant application has been filed initially challenging the memo dated 8th January to August 2014 by which the applicant was charged. And so, however, during course of hearing, the departmental representative have produced another communication dated 7 September 2015 and submitted that the subsequently the department had realized that inadvertently the draft article of charge and draft statement of impeachment misconduct were issued by memo dated such and such. For that, the memo dated, they sent copies of the article charge. However, the counsel for the application submitted that no such letter was received by him. The respondent not audition to show that said articles of charge and statement impeachment was served upon him. However, on the basis of the said charge sheet, they have proceeded with the department proceeding. Then, can you see the page 163? Had both sides participated, perused the records, it is noted that the applicant had initially challenged the impugned draft charge sheet dated 8th August 2014 on the ground that the said charge sheet was issued in the draft stage. Further submitted that the counsel for the applicant and the subsequent articles of charge and statement of misconduct was not received by him. However, the respondents themselves, they do not want to proceed with the impugned charge sheet dated 8th August 2014, as well as the communication dated the subsequent issuance of second so-called this imposing punishment, as well as the charge sheet dated, commission dated, become influxed. Accordingly, only disposed of. Then, Mana Kalidi issued the charge sheet. Second time, 169. Last sentence. This memorandum cancels the department earlier memorandum dated 8th August 2014.
That is the draft.
Draft. Then, what is the bar to issue a
When was the draft charge sheet issued, Mr.
8th
2008?
August 2014.
2014.
14.
So we are.
Matter was pending. Matter was pending.
Matter was pending.
Pending.
You revoked that charge sheet in 2022. You revoked it and issued a fresh charge.
Fresh charge sheet.
On the same charges.
Because this is the draft one.
So it is a stale proceeding.
No.
Because his allegation was he has manipulated the records pertaining to the time of 2014. You yourself did not proceed with the same.
No, can't see. His allegation does that the department proceeding cannot continue with the draft charge sheet. He has not been served with the charge sheet.
Mr. Mukherjee, 2014 was the first charge sheet.
Yes.
You have, forget what he has said. You have withdrawn the proceeding on the basis of that charge sheet. You went to the second show cause stage.
Yes.
You allowed the entire proceeding to be dropped. And you have now saying that in cancellation of 2014, I am issuing a fresh charge sheet.
What is the bar?
Bar is no bar. Bar is what we are saying, it becomes a stale charge sheet.
No, not a stale charge sheet.
Why? What is the allegation?
Can you see?
The allegation in 2014 is the same as the allegation in 2022. How do you explain
There is a
this?
procedural defect. There is a procedural defect.
The present writ petition.
And while the second so-called notice has been issued, but now what is the final stage? The tribunal may be directed.
No, he will give second show cause notice. Have you replied?
Yes.
You have given the second show cause notice reply.
First I have replied, second I have not replied because I have filed this application before your lordship.
Where is that again further charge?
Because he has not replied to the first so-called notice, then we have given a reminder.
Page 7.
Reminder you have given. Then
Page 7.
he will file a
Page 7 of supplementary affidavit, which is 7th of March 2014, 2024.
But till date he has not replied it.
Retirement to the
When matter was pending before the court or tribunal, there cannot be stale charges. If subsequently they realize that there is some defect, ordinary that otherwise employer has every right to recall the charge sheet.
But not to act unreasonably.
Madam,
Employer has all relevant power, but not to act unreasonably.
no, unreasonable. Because the tribunal said that this you cannot proceed because of the draft charge sheet. Then we have taken accepted because
Reply rejoinder completed before the tribunal. Tribunal reply rejoinder completed.
completed.
So do we send it to the single bench for hearing of the main matter?
Yes.
Do you oppose Mr. Mukherjee to that?
No.
The present writ petition has been preferred, challenging an order dated 6th March 2024 passed in the original application in short way being OA 307 of 2022. By the in the said order, it was inter alia observed that বলে কোট আনকোটে এই প্যারাগ্রাফটা দিয়ে Mr. Niyogi, learned advocate appearing for the petitioner submits that initially a draft charge sheet was issued against the petitioner
8/8/2015.
on 8th of
Suspension to the suspense করছিল 13 8 March 2013
where is the
8/8/2014 madam.
Where is
8th
that
August
charge sheet?
2014.
8/8/2014
108.
page 108 page
Charge
108
sheet, we want to go to church, earlier church.
108.
108 page 108
A draft charge sheet was issued against
Page
the
109.
petitioner on 8th of August 2014. Bracket page 108 এ লিখে রেখো তো। In connection with the same, in connection with the said disciplinary proceeding, the petitioner was suspended
Suspended on 8 May 2013.
suspended on 8th May 2013.
2013
8th May 2013.
and my promotion was withheld.
Stop. When it was revoked,
It was revoked on my lord on
By governor.
by the governor on
In the month of May 2000.
20th of January 2015.
the said suspension order was however revoked on
28th of January 28/1
8th of
2015.
January 2015.
15.
Page.
Abutment is there. Page, we have not annexed that. Abutment is there.
But their government is there page this has not been added.
28th of
Page-
January.
Page 156.
28th of January 2015. However, he was not allowed to join his post.
So,
Join his post. Though he twice visited the office to join the post. ওইটা আগে লিখবে আর কি। And though he visited the office twice thereafter, he was not allowed to join. In the midst thereof, a charge sheet was again, and fresh charge sheet was again issued. Vide memo dated 22nd of April 2022, cancelling the earlier draft charge sheet issued vide memo dated 8th August 2014, challenging the new charge sheet dated 22nd April 2022. বলছি। না, এইটা তো আবার 2017 ফাইল করেছিল।
এলো কিছু জয়েন করতে দিল না বলে ও এলো।
in the meets there আচ্ছা ওই in the meets thereof এর আগে একটা লাইন দাও in agreed by such denial to resume agreed by such denial of the authorities to allow him to join his post, the petitioner filed an original application being way 282 of 2017. During pendency of the same, তারপর ওই charge was issued. ঠিক আছে? Charge was issued. The learned tribunal finally heard the matter and passed an order on 31st March 2022, wherein 31st March 2022,
Page 162.
recording that the respondents do not want to proceed with the charge sheet dated 8th August 2014 and the second show cause notice pertaining to such proceeding was accordingly observed to have become infructuous. Mr. Niyogi submits that no leave was also granted to the respondents to issue any fresh charge sheet. But in defiance of such, leave was granted to issue any fresh charge sheet. Fresh charge sheet, which was ultimately issued, repeating and reiterating the allegations incorporated in the earlier charge sheet. Mr. Niyogi, on our answering our query, Mr. Niyogi submits that the petitioner was constrained to participate in the proceeding initiated by the new charge sheet, and in connection with the same, a second show cause notice was issued, and subsequent thereto, and during pendency of the present petition, a further notice has been issued on 7th May 2024. Right? Which is that notice? Second show cause,
Second show cause.
which is that?
Well, this is page 7, man. Page 7 of supplementary evidence.
Second, yeah. 7th May 2024. In the stop, the petitioner accordingly prayed for an interim order. Prayed for an interim order, but the learned tribunal, without rejecting such prayer for interim order, observed that the said interim order may be considered by a bench consisting of 2 members. In the event the order of punishment is passed in view of such refusal, the respondents may pass the final order of punishment against the petitioner, and in such circumstances, unless an interim protection is granted, the petitioner will suffer irreparable loss and injury. Mr. Mukherjee learned AGP learned advocate appearing for the state respondents, however, denies and disputes the contention of Mr. Niyogi and submits that having participated in the proceeding initiated on the basis of the charge sheet dated second charge sheet, 8th of August 2024,
22nd April 2022. 22nd April 2022.
Page.
Page 97, man.
Packet page 97 দিয়ে দিয়ে কি লিখলে sentence?
Submit that at the participated meeting initiated on the basis of the charge sheet dated
bracket in 97. The petitioner cannot pray for any interim order. The petitioner cannot turn back and challenge the same and seek any interim order. Prima facie, we have heard the learned advocates appearing for the response. Prima facie, it appears that the charges contained in the draft charge sheet are almost identical to the charges incorporated in the new charge sheet issued about 8 years thereafter. in the said conspectus and as a prima facie and as prima facie an arguable case has been made out by the petitioner. The grant of the interim order, grant of an interim order will not cause more prejudice to the respondents than the absence thereof is likely to be caused to the petitioner. In view thereof, this court directs that the respondents would be at liberty to proceed with the disciplinary proceeding, but no final order shall be passed without the leave of the learned tribe. Stop. Leave of the learned tribe. Or the disposal of. আচ্ছা ঠিক আছে, stop. Mr. Niyogi further submits. Mr. Niyogi further submits that the petitioner is languishing before the tribunal since the year 2022, and there is no possibility towards constitution of a bench of 2 learned members, bracket A, 1 judicial and 1 administration. Stop. In terms of the notification, notification ছিল না? In terms of the notification dated, in terms of the notification issued, the claim comes with the within dated. The subject matter comes within clause B of the said notification, being a quote unquote a beta. Notification dated to the 23rd November 2022. From the records further reveal that the original application was initially heard by the learned single bench and was admitted and was admitted and after such admission, the learned single member ought not to have directed placement of the same for hearing before a bench comprising of 2 members. Mr. Mukherjee has also placed before us an order passed by a bench presided over by the Honorable Chief Justice in WPA bracket A P/125/2024, by which the learned single member was directed to hear and dispose of the original application on merits. In the said conspectus and with consent with Mr. Mukherjee, in the said conspectus, the present writ petition is disposed of with a direction upon the
Chairman in charge.
Direction upon the learned single member to hear and dispose of the original application on merits, as expeditiously as possible and preferably within a period of. When is your retirement?
Well, I will I entered service in 2005 on the basis of
When is your retirement?
retirement leave. After that,
Within 12 weeks from the date of communication of this order to the learned registrar of the learned tribunal, without granting any unnecessary adjournment to either of the parties. The writ petition being such and such is accordingly disposed of. There shall, however,
till that time, well, they will not pass any final order. Otherwise, they will come to the high tribunal
said that.
and they will get it interim order. Well, otherwise, the department will file an application for interim order and tribunal will pass that order. Kindly protect me that unless the matter is heard, no final order should be passed. Kindly protect me on that. Unless the matter is heard.
We have said no final order shall be passed without the leave of the tribunal.
No, what I am submitting, the respondents will make an application for passing the final order. And without hearing, my experience is without they will pass, order will be passed. Kindly protect me on that track. Until the matter is heard, until the matter
They will take leave from the tribunal before passing.
they will come to the tribunal and say, give me leave, then their leave will be granted. This is my experience. Yes, kindly protect me unless the matter is heard. Unless the matter is heard.
Hearing must be given to you.
Yes, unless the matter is heard.
So, Mr. Niyogi, what do you anticipate?
But I'm anticipating in the meantime, if the administrative member retires, nobody comes. That order will infructuous, they will give effect to that order. So my submission is, until the matter is finally heard, they will not pass final order. Kindly protect me that. Let it be heard within 6 weeks. I have no objection. I have no objection. With my sad experience with tribunal, I am saying, Your Lordship.
8 weeks. ওই 12 weeks টা কেটে 8 weeks করে দাও আর ওটা no final order shall be passed without the legal till the disposal of the original application.
I'm grateful, Judge.
When a liberty may be granted to apply before the tribunal, if the dismissal proceeding final order is passed, to apply for a leave to communicate.
For you can always
No,
apply for final.
If necessary, you pass an order, but that should not be given effect. That I am saying that.
But to kindly consider that I have challenged
They
the,
be passed,
I have
but
chal-
it would not be given effect to without the leave of the tribunal.
but kindly consider, I have challenged the
Mr.
very,
Mukherjee, suppose today you prepared the final order
No.
and you come to the tribunal. This is a disturbed situation. We are saying
Yes.
that let it be heard by a single member. Now, if suppose final order and if you pray for leave, but Mr. Niyogi, the tribunal will hear out the matter when
Yes.
leave
my lord,
without.
kindly consider that the learned single judge. I have appeared in so many cases, all were adjourned to 2025 on the ground that no judicial member is there, as a question of law is involved. But I tell him, Your Lordship,
But you have
Oh,
to
that
you have to
portion
consider
of the order is being set aside,
my lord.
has been set aside.
But I do not know if Your Lordship pass this
Directly
order,
has been-
unless the matter is heard, no final order should be passed. Nobody will be prejudiced. Let it be heard within 2 weeks. I am ready. Nobody will be prejudiced by the order.
No, file will be,
Nobody will be prejudiced by that.
not till the disposal of the original. Yes,
I am grateful, Judge.
supplementary affidavit.
I am grateful.
Appropriate action for vacating. Yes, next.
Lordship, Mr. Shobhan Majumdar appearing for the petitioner, Lordship, I'm praying short Passover, Lordship.
2 weeks, yes.
So item number 7, Mr. Ujjwal Mukherjee is appearing. On the last occasion, Lordship has referred one judgment and asked Mr. Mukherjee to look into it. Lordship, Mr. Mukherjee has find out another judgment. Recently, it was it has come to his knowledge. He is praying for 1-day accommodation, Lordship. He has informed me. He came to court today, to your Lordship's court. He asked me to pray for 1-day accommodation just to. That judgment is contrary to the judgment that Lordship has given to us. That was the current judgment. That was, I think that was not in any book. It was not
the judgment was not reported as yet. As per Mr. Mukherjee, like Lordship, give me 1 day accommodation. Tomorrow we shall come and assist your Lordship.
Next Tuesday.
Next.
My lord, your lordship, kindly excuse me, my lord. Your lordship, my lord, asked me to find out one judgment so far as the plain paper application. My lord, I failed, my lord. This is my inability, my lord. But
No, you argue, Mr.
my lord, I learn.
Next Tuesday we are keeping. Do you have the
Tuesday.
judgment?
No, Lordship. He just informed me he has found out something.
All right, next Tuesday.
Grateful, Lordship.
Eight, please.
Also have challenged the impugn order passed by the tribunal, state administrative tribunal. Lordship, before going to the impugn order, এই 32টাকে ধরে তো 5-1 32 এই 15
Yes, Mr.
the petitioner was appointed as a chowkidar in the year 2003. Now, Lordship, subsequently, by a subsequent letter, petitioner was joined in the post. Subsequently, petitioner was transferred as a Group D staff from the disaster management to the office of the collector in the year 1st September 2010. Now, petitioner duly joined in the office of the Lordship, the district collector from the office of the district disaster of management upon giving resignation in terms of the order dated 8 September 2011. Now, Lordship, the petitioner
Who was
duly
your
joined.
first appointment letter?
Kindly come page 53.
This is your first appointment letter?
Yes. 3rd September 2003. 3, yes. Group D for the post of Chowkidar. Well, also medical examination, everything, what I am not, this is not at present relevant. Now, Lordship, kindly come page 33. Now, petitioner was transferred to Group D from, Lordship, the disaster management to the office of the collector, Uttar Dinajpur.
But your appointment was under the Directorate of Relief.
Yes, the disaster management, I was initially appointed. Subsequently, my
page 53.
Page 53.
Where do you find disaster management? This is Director of Relief, page 53.
Terminally disaster management.
Directorate of Relief.
Relief, Lordship, perhaps it was previously 2003. Subsequently, it has been renamed as disaster management.
Yes, under Directorate under West Bengal Reliefs Department. Very good. Then what happened?
Now, Lordship, kindly come page 33.
The
petitioner was transferred from the post of, Lordship, the this was initially was
page 33 is one recommendation sending here with a prayer of Mr. Jha.
Yes, in the post of
requesting
Group D from the disaster management to the office of the collector. So DM office, Lordship, the collector office, I has
Very
was
good. Then what
transferred.
happened?
Now, Lordship, kindly come. This is the page 34. Lordship, this is a transfer from the Lordship, this is the same order. Prayer for transfer. Now, page 36 is also the Director of Disaster Management giving no objection for transfer. Now, Lordship, I join. Now, subsequently, Lordship, kindly come page 22.
show us the joining.
Page
after the-
40.
Eh?
Lordship, kindly come. Yes, I join. Kindly come page 20. Transfer of Sri Asutosh Jha, Group D, Director of Disaster Management to the Office of the District Magistrate, Assistant Secretary, Disaster Management.
20.
Page, sorry, page 38. I'm sorry, page 38. আগের পেজগুলো তো কেটে দিই।
In response to an complaint.
Now, Lordship, kindly come
Yeah,
page,
just a moment.
page 37. সাজাতে হয় সিস্টেমেটিক্যাল, নভেম্বরটা আগে হয়ে গেছে।
So, when did you join the?
Lordship, kindly come page 37. In reference subject caption above, the undersigned is to inform that accordingly sanctions strength Group D under this collectorate at present same post are lying vacant. Necessary steps may be taken within short span of time accordingly.
Where is your joining letter in the collector's office? You tendered resignation to directorate and joined. Where is that joining?
Lordship, apparently I joined. Lordship, subsequent documents I am showing. Lordship, what is the dispute? The dispute is.
Where is your resignation then? Resignation. You resigned in the directorate of relief.
Lordship, resignation for the post of, this is a previous post, and subsequently I was allowed to join as a Group D in the office of the collector.
Where is your resignation?
Resignation I have
resigned. You have resigned from the directorate.
Now, Lordship, this is the nomenclature. Lordship, this is the my crux of. Now, subsequently, Lordship, what is happened? Lordship, kindly come page 40.
Now you were in unauthorized absence. You did not join the magistrate's office?
No. I joined, Lordship.
You did not join.
Lordship, I will come. Lordship, kindly come. 2022, what happened? When I went to the office of the collector, Lordship, I was prevented to join, to discharge my duties in spite of joining. Lordship, kindly come the so-cause notice. It appears from the records that you are serving as a Group D night guard at Nijarat section of the Uttar Dinajpur Collectorate. And it's also found that you are absent from the office of duties without any prior approval of the appropriate authorities or any prior information, which is gross negligence of a duty at part of state of the employees under the West Bengal service rules, and your salary has been withheld. Whereas it has been noticed that several so-cause notice has been issued to you, named from this office for submission of your reply for unauthorized absence from the office duties, but till date, no satisfactory reply has yet been received from you, from your end, in spite of the so-cause notice, which is gross negligence on your part as a state government employee serving under the West Bengal service rules. And in pursuance of the rules and resignation as laid down in the West Bengal service rules, you are hereby directed to explain in writing within 10 days as to why legal action should not be taken against you for such unauthorized absence on violation of the West Bengal service rules, and as to why your unauthorized absence from the duties be not treated as the
from 2000
as known and as per the West Bengal service rules, and as to why the legal action should be. So this is the so-cause notice. Now I have submitted reply to this so-cause notice.
You did not join from 2012 to 2022.
Also, kindly come to the next letter, page 41. In pursuance to the order such and such, the Director of Disaster Management such and such, has joined in the office on 21st February 2012.
Please read further.
To the post of Group D, and after break of continuous service due to undersigned leave as per 34.3 note 1, and the pay of Asutosh Jha Group D is hereby fixed a pay, Lordship, the 17,243,600 sale 1 as per ROPA 2019 plus admissible amount. His pay is hereby fixed in the following manner. Now my pay has been reduced. Now, Lordship, kindly come. The next last. The pay so fixed will be treated as a provisional and required modification will be made as per the overdrawn of pay and allowances. If detected, subsequent detection amount will be recovered herewith, then the above fixation, service, book and post group D should be considered. Now kindly come the page 42.
This is the order of punishment.
This is the order of punishment, Lordship, without any disciplinary proceeding. My first ground. Only so cause, on the basis of so cause, I have given so cause a job. Now, this impugn order has been passed 26 September, May 2022. Now, Lordship, without any proceeding, without any charge sheet, without any, Lordship, the discipline.
Next, what?
Now, Lordship, kindly come, page 42. Asutosh Jha Group D has been transferred to, with effect from 14th October 22 to the SDO's office, Islampur. Last column, 14. Now, let's say here is my two prayers. First of all, my salary has not been continued as on from 2000, Lordship, the 12, 2016. So this is the salary. I am not getting the salary from 2016. And Lordship, my pay scale has been reduced without any proceeding, without any due process of law.
Now, have you joined that post?
Yes. Is continuing the service.
SDO Islampur you are serving?
Service. Yes, I am continuing
and
the service.
You have not been paid the salary from 2016 to 2022 for
20.
5 years because you were unauthorized.
22, 2016, 22.
So you were in unauthorized absence.
According to them, but Lordship, this is my reply to the so-called.
What is your reply? Where is your reply to the so-cause? So tribunal has found you to be.
Tribunal has not gone to the merit of this case. 2003, this is not my case at all. Tribunal has gone to the case of 2003. This is not my case. My case is.
Your prayer was to give the salary for that 5 years period with interest. No other prayer you have made. This is your emboldened before this court now. No averment, nothing, no disciplinary proceeding was initiated, punishment imposed.
Yes,
On the contrary,
Lordship, kindly come to my application before the trial.
Come to your application, come to page 30. এখানে এসে গায়ে জোর হয়ে গেছে. You will not place things before the tribunal. The tribunal was irritated, so imposed cost upon you.
Kindly. Lordship, what is my grounds before the tribunal?
Gaji, that is, you were not there before the tribunal. Yes, tribunal কিছুই বলেনি.
Yes, Lordship, kindly come page 30. Prayer B. Kindly come page 30, prayer B. Lordship, my salary from 1st October 2016 to 21st April 22.
Mr. Mukherjee, when your salary was curtailed 2022,
yes,
you did not do anything. You accepted that order.
No, I have challenged this order.
Challenge 2024, you are challenging after 2 years.
Sir, this is the original application I have filed long back.
When have you filed?
23. 23, and it was affirmed on. Six to 8 file
20th of April 22 was the showcase.
Yes.
You give a reply to the showcase.
Yes.
Now, after 1 month, they passed the order of deduction in salary.
26th May 22.
Huh? Now in 26, you should have challenged this order. You
Sir,
did not challenge this
Sir,
order.
I have challenged this order in the 23.
After that, you were posted to Islampur. You accepted that. You went and joined there. Now after that, you are coming. What you are saying that give me the salary for that period, allegedly unauthorized absence. No challenge, nothing.
Also, immediately this letter of joining has been issued.
Yes, Mr.
But-
Mukherjee.
Kindly say page 40 for a moment.
40.
40. Dated 20th April 2020.
Huh.
Why after sir? He has been given 10 days. Where is the reply to the 10 days? Next document.
They have final past a fund.
But this, has he replied to this 10-day notice? Replies to the so-called notice? 10 days was the maximum time. Therefore, in pursuance of the rules and regulations laid down on the West Bengal Service Rules, you are hereby directed to explain within 10 days as to why legal action should not be taken against such unauthorized absence or violation of such action. 10 days, that 20th April, then the 1st May.
But Mr. Mukherjee, where is the charge sheet?
Charge
Where is
sheet.
the...
No, this is the so-called notice.
As
But it is dice known, but so but unauthorized absence. He has not been for the period to be not to be paid counted for any service benefit.
No, we are not saying that. When you are imposing a punishment, you not initiate a proceeding. Only show cause will suffice.
But if there is no reply to the so-called notice,
There is no provision. Under the
Mr.
service
Mukherjee.
rules, Mr. Mukherjee,
No,
you are
we are
an
not
expert in service rules.
What is the content or motto of the issue of so-called notice?
so-called notice.
Why I shall not take legal action against you?
Yes, no.
Then the legal action
He
comments from the certificate charge sheet.
he can give reply that reply is satisfactory, chapter closed. If reply give
So he has not given any reply
reply, then what
and did not show the cause.
cause?
Why he said they would not be take legal action against the employee.
No, that's only that.
Employee has not given such answer.
Then what the
So
government
you proceed, take legal action.
take actions,
Legal action means
but
follow the procedure.
he is not dismissing from service or removal from service. Nothing. Only that diational period should be. Why should not be diational period? Should be.
Diasion, it has to be declared by holding a proceeding, Mr. Mukherjee.
In their service jurisprudence, the point. If somebody is absent, unauthorized absent, he may be removed from service. This will be proceeding.
No, what he is wanting that regularize that period. Why he is wanting? Because on the basis of a show cause notice, you have already imposed the punishment.
Can you see the order?
But your tribunal says that there was unethical action on his part. Where was the unethical action?
Unethical action.
He
He resigned from some other place.
No, he
Yes.
resigned. Resignation was accepted. There was
Tender his
continuous.
resignation. But if he tendered his resignation in some other place, then service will be new service.
If it is new service, then why you want to treat it as a dice non?
No. What a kind of thing. But after serving 8 years, he tendered resignation, which was accepted, and after joint service,
That was in 2011.
2012.
Anyway, 2012. Now thereafter he joined your office.
Yeah.
After joining, he was in unauthorized absence.
He wants a service benefit from 3rd September 2003.
So that the tribunal will reject. No, he is wanting only page 41, that period regularization. Page 41, Mr. Mukherjee. 41.
What a page.
Then after that, after 26 May,
Where is your resignation letter? You have not annexed that.
no.
There is no resignation letter.
হতে পারে নাকি? You have resigned and you
Resigned
joined.
from the-
Your resignation was accepted.
This is 2003.
So you do not have to prove it. Kindly come to page 38.
Lordship, this is 2003. I am not in dispute. My dispute is from 2012-16.
Is by issuing a letter dated 8/9/2011, come to page 38. Assistant Secretary of Department of Disaster Management Department. He is saying that department has no objection in accepting his resignation.
So this is resignation because previously I was in the different post in the group D.
Yes.
I resigned from this post and accepted new post.
Yes.
Resignation, this means to say this procedural, Lordship,
No. Resignation.
this is resignation, not that employee relationship has been ceased to exist.
Yes.
But this is not the resignation. Resignation is, Lordship, I have resigned in the post of group D as a this post and I accepted in different.
Different.
Yes.
Yes.
Then why resignation?
So there is no relation because
No.
as
My dispute is, Lordship, 2000.
service.
No.
You don't want to get any benefit from
No,
your
certainly not.
service as group D of disaster management group.
No, certainly not.
So forget about the chapter. Now you join in
2012.
the collector of Uttar Dinajpur. In
Yes,
the office of the collector Uttar Dinajpur.
Yes, I joined on 21st February 2012.
21st February 2012.
Well, now my unauthorized leave, according to them, from 1st October 16 to 21st April 22. 5 years, 6 months, 20 days.
তারপরে absent.
From 2016 to
20.
2022, unauthorized.
And that punishment was imposed without a disciplinary proceeding.
So what dice not only so cause notice is necessary. Dice none. Dice not only so cause. If termination is necessary.
Where is the dice non you find?
What?
Dice non, where do you find in the
Proper
final?
so cause.
Page 40.
Yes, show us.
Therefore, in pursuance of the rules and regulations as laid down in the West Bengal service rules, you are hereby directed to explain in writing within 10 days as to why legal action should not be taken against for such unauthorized absence for violation of the West Bengal service rules, and also why your unauthorized absence from service
Shall not be treated as dice non.
to be treated as a dice non as per a
So, Mr. Mukherjee, where is that proceeding? He failed to give this. So you call him and impose a punishment. Punishment you are giving in 2022 next page. That already decided you will you will not get the salary for 5 years, 6 months.
If somebody so cause notice is issued, no reply is given.
You read the next line.
Yes, sir. Should not be taken for certain
why?
substance. And this so cause notice should be treated as a final, and thereafter legal action.
Again, you are Mr. Mukherjee, you are going as to why legal action as laid down. Where? In the West Bengal service rules should not be taken against you.
Treated as final notice.
Now you show the West Bengal service rules has empowered you to declare unauthorized absence as dice non or anything like that, even after or if no reply to the so-called notices.
Can you take it up to bottom of the today I'm handicapped. Please not.
No, we are staying this order.
What?
Tribunal order we are staying, otherwise you will recover this 10,000. Punishment deserves to be punished. Why this tribunal was so annoyed? District magistrate is directed to deduct the amount of salary by 5 installments. Unethical action. What is the unethical action?
Suppress the fact.
What suppress? Where is the suppression?
The applicant has tried not only to extend his service benefit for a longer period by making such a false pair.
Key false pair.
False pair.
Finds also tries to find shelter.
Supplementary evidence has not been supplied to me.
Yes, sir. Annex করেছি।
Wait.
আপনাদের supplementary evidence annex করেছি। এই যে page 43.
সেটা তো করা যায়নি।
43.
ও চ্যালেঞ্জ করেছে 26শে মে এই ছাড়বে 2 বছর পরে।
ঠিক আছে, এফিডেভিট দিন না। ও না, এটাতে অ্যামেন্ডমেন্ট অ্যাপ্লিকেশন।
Supplementary affidavit has not been supplied to the.
Supplementary no amendment.
Filed before the tribunal.
Supplementary affidavit is we file.
No. This is an
Page
application for.
43, this is the supplementary, we file.
The amendment was application was filed.
amendment না, এটা supplementary, মানে উপরে লেখা আছে supplementary.
Amendment or application.
No, this is filed by us.
Yes.
আর কোনো supplementary affidavit কিছু নেই, আপনারা কিছু ফাইল করেন।
Records reveal that the original application, in short way being 6/28 of 2023, was preferred by the petitioner, challenging inter alia a memo dated 26th of May 2022, issued by the collector Uttadi, Mr. Mukherjee, learned advocate appearing for the petitioner, submits that the impugned memo dated 26th May 2022 by the impugned memo dated 26th, a punishment was imposed upon the petitioner and his pay was fixed in pay level 1. Bracket is 17,000 to 43,600. Due to unauthorized leave for the period from 1st October 2016 to 21st April 2022. Such punishment was imposed without holding any regular disciplinary proceeding. Such punishment could not have been imposed. Has joined his duty to the post and after breaking continuous service due to hereby
স্ট্রেট করা হচ্ছে বা এখানটা
level 1 basic level, level 1. Level 1.
Stop the period from 1st October 2006.
Such punishment could not have been imposed.
Could not have been imposed without holding a regular disciplinary proceeding. Stop. Without considering such fact, stop. The such argument as advanced was glossed over by the learned tribunal, and a cost of rupees 10,000 was imposed upon the petitioner, directing the collector Uttar Dinajpur to deduct the said amount from the petitioner's salary in 5 equal installments from the month of April 2014. Month of deduction made?
No. Deduction
Why equal installments from month of April 2014? He ordered দিয়েছে ওটা স্যালারি পাচ্ছি না তো 14 কি করে
সেটা তো আপনার এই অর্ডারটা
so that is a spelling mistake. There is a 24 হবে না ওই by 5 equal installments করবে Mr. Mukherjee, learned AGP appearing for the state, however, submits that admittedly there was break in continuous service of the petitioner, and as such, and as the petitioner did not reply to the final show cause notice dated 20th of April 2022, appropriate order was passed with a memo dated 26/5/2020. So we have heard the learned advocates on record. Stop. imposition of cost is discretionary in nature, and the reasons towards such imposition of cost needs to be incorporated, needs to be specified. Prima facie, it appears that only observing that prima facie, it appears the learned tribunal, on the basis of an observation that the petitioner had adopted unethical actions, imposed the cost. Such finding prima facie do not stand fortified with appropriate reasoning. It also prima facie appears that the memo dated 26th of April 2022 was issued without holding any regular disciplinary proceeding. In the said conspectus, the said conspectus, the order towards in the said conspectus, the সেটা সাইডই করে দিতে dispose of করে দিয়েছে dispose of করে দিয়েছে এই তো পাবেন there, in view thereof, there shall be an interim order of the direction towards imposition of cost till the disposal of the writ petition, opposition for which in view thereof, the respondents are restrained from the direction towards imposition of cost of rupees 10,000 is stayed, and the respondent number 2 is restrained from deducting the said amount from the salary of the petitioner till the disposal of the writ petition. Stop. The respondents are directed to file their affidavit in opposition 4 weeks. Reply thereto, if any, be filed within 2 weeks thereafter. The parties would be at liberty to mention the final after the expiry of the period as specified above towards exchange of evidence. Yes, next.
But item number 9, my lord, I'm for the petitioner. My lord, if you also kindly take it up tomorrow, I'm a little bit handicapped today. I appeared through online, but I did not come up the briefs. If you also kindly take it up tomorrow.
Would Mr. Mukherjee, you are there?
Yes.
You have filed your opposition?
Yes, yes. They have subbed me a copy. They have subbed me a copy.
Reply, you have
My
filed.
lord, reply is not required because the facts are little bit admitted. All the facts are little bit admitted.
Next Tuesday, you
No
have
problem.
opposition.
We have already filed opposition.
You have given?
Yeah.
Ekhane? Wait, no, Mr. Mukherjee. Opposition is not. What is?
The affidavit has been affirmed and I shall file it
In course of
in course of today. Perhaps it's
My lord, only one more pair, my lord. There's one more pair, my lord. Since the interim order expired on 31st of August, kindly extend it till next Tuesday.
A copy of affidavit in opposition was served upon you.
Yes, my lord, subbed upon. Subbed upon.
Mr. Mukherjee has given to him, but not to us.
Your Lordship, there has been some mistake, Your Lordship, I shall file it in court.
Mr. Mukherjee, learned AGP appearing for the state submits that a copy of the affidavit in opposition has already been served upon the petitioner however, he prays for an accommodation to produce the affirmed copy of the said affidavit. Prays for an accommodation to produce the affirmed copy of the said affidavit in opposition. In view thereof, leaves the matter for further. Mr. Hard Mr. Ghosh, learned advocate, appearing for the petitioner. In view thereof, leaves the matter for further consideration.
The post has already been filled up. Post has already.
Well, that can't be, my lord. There is no selection process. Someone has been transferred and has been posted there. Someone has been transferred and posted there. There is no selection process.
Considered that interim order, then we said that from filling up in which the petitioner was engaged.
His brother is working. His brother is working that post.
My lord, I do not have any
His brother.
Brother. Kamal Bishra, petitioner's brother.
What he is
My lord,
saying.
my lord, I do not have any instruction to that effect, my lord. I do not have any instruction.
Your client wants double employment. Brother working, he will also work.
But I do not have any instruction, my lord, to that effect. My lord, kindly take it up next Tuesday and interim order may be extended till that period only.
Leaves the matter for further consideration on the interim order. So next Tuesday, the interim order passed earlier. As there had been no change in the circumstances, the interim order passed earlier is reinstated and extended till the disposal of the original. Extended till the end of disposal. Till the end of October. No, September. We are keeping till the end of September or until further orders, whichever is early. Yes. Next.
Much obliged, my lord. Grateful.
May it please your lordship. Lord, the affidavit of service may be kept on record. The affidavit of service. Lord, this is one of the most unfortunate cases where the petitioner before your lordship.
Why yes, 19 September is the date.
19 September. But has been fixed for hearing.
Hear it on 19 September.
Is it 19th? Let me check it. No, fixed on the before the tribunal. But this I have to come against the order of the tribunal.
What interim order you are wanting?
Yes, I want the interim order. I tell your lordship. This is one of the most unfortunate.
So on consent of the learned council and the.
No, the matter was taken up before the.
You have given consent. Read the order first.
Yes, I have seen. The interim order was not passed. There was no consent. The consent for taking up the matter.
What interim order you want?
For consideration of sitting singly. For consideration for sitting singly, the matter was taken up. It was heard by the single judge before the tribunal. So for that the consent was given.
Your prayer is to disburse the salary.
Yes, I tell your lordship.
Disburse the area salary.
Not area. Lordship, the petitioner is still working. There was no proceeding, departmental proceeding, any charge sheet, nothing. Suddenly, his ID and password was blocked. He could not join his service, although he regularly attended the office. Thereafter, my lord, and he was getting the salary. Now, on and from, he was paid salary up to July.
Page 47.
Thereafter, from
what
July.
Interim order you want? Tell us.
To disburse my salary, although I am working.
Final relief. That is the final relief you have said. That is the final relief in the original application. Come to page.
No, there is an interim order also.
To us what?
Interim prayer. Yes, from the interim relief, if any, sought for. Pending disposal of the instant original application, applicant is praying for the following reliefs. The order directing the respondent author to disburse the salary of the applicant. There is no proceeding, Nothing of the sort whatsoever.
Mr. Mukherjee, you have got instruction.
And
Huh?
but I tell your lordship, the situation of the petitioner, they are living in chill penury. They have no money.
Mr.
As a
Mukherjee,
matter of
tomorrow?
the petitioner had a mild attack.
19th September was fixed. That's what the
19th
department thought
September
that,
fixed before the tribunal.
No, please tell us the reason now, why it has been withheld.
Can you take it next week?
No, he can't wait. Lordship, in the meantime, Lordship, I tell the situation of the petitioner.
So, leave that much of jurisdiction to us. You're saying no?
No, I'm sorry. It's a slip of the tongue. I'm sorry, my lord. That's right.
No,
I'm sorry. I did not.
That cannot be done without.
Once focus notice was issued,
Reply given.
that means
No,
on
reply
disciplinary
given.
proceedings-
Thereafter, they are sitting tight. No proceedings started. No charge sheet. Nothing. He is still working, but not getting salary. Say prejudging of issues. Up to July, he got his salary. Since on and from July 2023, he's not getting any salary. What is the reason? I'm asking this question to myself. Either you start a proceeding against him, I am ready to face that, or a charge sheet. But in this way, salary cannot be withheld for any reason whatsoever.
All right. Come on Thursday. Take instruction on that and come back and tell us. Any suspension order issued or not?
Nothing.
Please take instruction. Heard the learned advocate appearing for.
And I have given also detailed representation. There is no reply.
Mr. Mukherjee, learned AGP appearing.
At
for
the top,
state
not the
respondents.
condition of the petition. If I am told,
You are not
yesterday
getting.
he had a
You are
mild
not
heart
getting.
attack. Yes,
Huh?
the petitioner, he had a heart attack yesterday, and they cannot call in a doctor even. They're living in this financial situation. They're living in chill penury.
Every government employee is
What employee? Although he is working there,
he's working, he will get free treatment.
but for that he will not disburse his salary.
No,
Is it
you
the
don't know
ground?
why. There's something.
No proceeding, nothing.
What I mean,
Arbitrary, absolutely arbitrary.
Mukherjee, there should be a
Yes.
reply, na? We have suspended or we have
Yes,
for this reason
nothing,
we are
nothing.
not giving. Only take that instruction. This is which district?
Purbo Bardhaman. Purbo Bardhaman.
Yeah.
All right,
Now
day
they are
after tomorrow.
on the
Mr.
verge of-
Mukherjee, come day after tomorrow.
Yes, my lord.
Next week, my
No, my lord, day after tomorrow, because their condition is.
Suffered a heart attack.
Yes,
Hardly learned advocate.
and he is the only earning
Sir,
member.
wait, sir.
Yes, I'm sorry. I'm sorry.
Heard such and such, and Ms. Mukherjee raised for a short adjournment to avail necessary instruction as to whether he's avail necessary instructions to release the matter for further consideration under the heading to be mentioned in the daily supplementary list of this court on Thursday.
May I
At the top.
indulge? This order can it be uploaded by this evening?
This order.
Yes.
Mhm.
So that immediately I can communicate that DM about what.
Yes, only take that instruction why salary has been stopped. Finished. Editor type property.
I'm glad to do.
In this matter, your lordship heard both of us. Four points are involved in this matter. Four points. The conditions which have been laid down in Rule 43, I have to satisfy your lordship that those parameters I have satisfied, as such I am entitled to short-term earning list. Now, my lord, kindly see, first ground, the first parameter.
So, Mr. Bhattacharya, please tell us if you come to the order of Justice Talukdar.
My lord, Justice Talukdar's order.
That is at page 32 of your, no, not 32.
My lord, page 87.
Yes.
Relevant portions I am reading before, also page 87.
No, Mr. Bhattacharya, just we have certain queries. This 27 January 2020, the memo 2014, the memo upon which page 87.
87 এর এই যে মেমোটা
Oh.
22nd January 2014
22nd January 2014.
14
This was the basis of the order.
22nd
January 20.
Yes, yes. Yes.
That is annexed to their affidavit opposition, page 31.
Yes, that I am showing, Lord.
Page 32 of the affidavit in opposition.
Yes. Yes. Page 32.
On the basis of this order, Justice Talukdar intervened and said that the order impugned is permanently stayed, but I have not gone into the merits.
Oh, my lord. Justice Talukdar.
No, our query is.
Justice Talukdar took into consideration these recommendations with regard to query permit.
Right.
These are the letters relating to query permit prior to 2016.
Right.
Justice Talukdar took into consideration while considering the order, impugn order dated 24th of May 2028. Now, your lordship, 24th of loose sheet I have given you lordship, but legible copy, though it is annexed as paragraph page 31A. I've given you lordship.
Which orders you said 24th?
24th May 2018.
Yes, we have gone through that.
24
Judicial intervention was, according to the officer, there was no judicial intervention.
No,
that is the ground. That is the ground which was taken, that there was no judicial intervention apropos the order of Justice Talukdar.
No positive order.
Now you were explaining to us that what do we mean by that judicial intervention?
That you lordship can receive.
No, our query before you is that this 27th of January 2014 order of the BLRO, whether any weightage can.
This is in respect of my earlier performance.
Right.
The paramount cause of action starts from 24th of May 2018.
Yes, that is the order which was challenged by you.
The order I challenged by before Justice Talukdar.
No. Yes. Before
Justice Talukdar. Now he lordship,
on the basis of this order,
Huh.
his lordship was pleased to stay this particular order permanently.
Yes.
Kindly, what has been stayed permanently? Kindly see.
Yes, yes, we know that.
Your lordship has seen. There are, first of all, I applied for STML. Your lordship can see his prayer dated 10th May 2018 in Form E for issuance of short-term mining license for riverbed materials. Apropos the subject, it appears that he has submitted an application in Form E along with annex enclosures by depositing a non-refundable sum of rupees 3,000 in form of application fees through Treasury Challan for short-term mining license for mining of sand over an area of 3 acres, 3 acres, kindly consider this, 3 acres comprising land over plots number 554 of Moja Dharnogram, jail number such and such pieces. I was also doing quarry business on the basis of license given by the authority in respect of this plot 554.
From 2011 to 2014.
This is a secluded plot having no relation with the other sand blank which are also given on auction and settlement to others. In this order, they have referred to Supreme Court judgment with regard to Deepak Kumar case, with regard to environmental matter. I have to satisfy the environment aspect. Secondly, in the second last part, I have to apply for LTML and participate in the auction. So, environmental aspect, requirement environment aspect, and requirement of application for LTML for auction have been stayed and quashed by the Honorable High Court. This is totally.
It has not been quashed. It has not been quashed.
Permanent stay. That
Tribunal court has said revisit the issue.
No.
Revisit.
No, revisit second part.
Where is the line that it has been quashed?
No. Kindly consider, your lordship will interpret the word.
No, that is
permanent stay.
That
permanent stay means, according to me, subject to lordship acceptance. Permanent stay means it will not survive any point of time. It is dead. It will no longer survive in the world. So it tantamounts to quashment. Even if the word quashment has not been issued by the Honorable Court, that does not mean that it will not construe to be meant as if it is quashed by the Honorable High Court.
Is it your submission that the grounds taken in the 24th May order cannot be repeated?
Cannot be repeated.
This is your argument.
This is my awesome. Cannot be repeated. And on those aspects, I cannot be denied license. On the basis of revisit order, TLRO passed an order on 12th February 2020.
So one query, Mr. Bhattacharya. If suppose today we quash an order or we say it is permanently stayed and ask the authority to revisit, there was no requirement for revisitation, Mr. Bhattacharya.
My submission before Lordship. Once something is directed to be declared as dead. By revisit, it cannot be alive. So revisit is for the purpose of further consideration.
Nothing remains, because if those three grounds goes, then they have no other option but to grant the temporary license. Then why didn't you insist before His Lordship that when you are permanently staying, then it becomes a formality, Mr. Bhattacharya.
Revisit, Justice said, revisit.
Keeping the points of merits open.
Kindly see the revisit said in respect, not with respect of merits. Kindly see what is the order, revisit.
Yes, that is page 89.
Kindly see the revisit. Revisit means according to the respondent is right to revisit the recommendation. Kindly consider, not with regard to permanent stay. Not with regard to permanent stay. To revisit the recommendation of RI on an in situ basis and make a just decision which would be then communicated to the petitioner.
Yes.
Petitioner to be communicated with the saying after the permanent stay, that means squashment and non-existing in the eye of law.
No, what did you say, Mr. Bhattacharya? 27 January 2024. That memo is not with regard to
this particular plot.
No, you said that it is not.
This is in respect of said particular plot.
Yes, yes.
Quarry permit.
In which you enjoyed from 11 to 14.
Since I was given the quarry permit of this particular plot 554, and on the basis of recommendation given by time to time, court said, on the basis of the said recommendation, you accept the recommendation, then pass an order. Otherwise, meaning cannot be given. Secondly, thereafter you will also kindly see second order. Kindly see the second order. Revisit after second order, you will also see the 12th February 2020.
No, please, page 89, come to the last paragraph. Which you are placing.
Oh, last paragraph. 89. Needless to iterate that in the event a positive decision is taken in favor of the petitioner, petitioner shall comply with the formalities.
Needless to observe. Needless to also reiterate.
To also reiterate that the respondent, DLRO, shall be entitled to make a decision purely on merits.
Purely on.
Now, this is beside the 2 points. One environmental aspect, one LTML aspect. He will consider other things. There are 4 conditions to be considered by them under Rule 43. I will show Rule 43.
What did you say that this is besides?
Beside the environmental aspect, the two aspect is
No, beside environmental aspect and LTML and e-auction aspect. These 2 aspects have been decided finally that it will not be required for me. Other conditions they may consider on merits. What are the conditions? Page Rule 43, my lord, kindly see. Rule 43.
Mineral, mines and minerals concession rules. এটার সাথে বাঁধা ছিল।
I will give the books, my lord. I have got them.
তুমি আনিয়েছিলে কার্তিক?
আছে বলছে, আছে আছে
Rule 43, my lord, kindly see. Rule 43, grant of short-term mining license of riverbed occurrences. The district authority, that means herein district authority has been described as district magistrate or ADM or district land reforms officer. The district authority or any authorized officer in case of riverbed occurrences may grant short-term mining license as per guidelines to be issued by the Commerce Department from time to time, extract or remove from any specified land within the limits of jurisdiction of on prepayment royalty at the rate specified from time to time under exceptional circumstances. Kindly consider, very important point. Exceptional circumstances, what? Judicial intervention. With regard to judicial intervention.
No, where are those 2 points? This environmental aspect is not under A, B, C, and D. You said that revisiting will be only on the basis of other aspects, apart from environmental aspect and the aspect of LTML. Those two have been decided.
True. Now, my lord, I am saying this. Judicial intervention.
Yes.
Judicial intervention. Meaning, my understanding. Judicial intervention or judicial order emanates when?
No,
if
before that, Mr. Vadaji, this out of these 4 points, according to you, which points have been decided finally by Justice Talukdar?
This point that order dated 24th May 2018, they said environment and LTML or e-auction.
Where?
Order dated 24th May 2018.
Yes.
These two.
Where is that?
24th May 2018.
Yes.
First, kindly see. At this juncture, second paragraph. And in the observation. And then yes, in observation of solemn order dated of one of Supreme Court of India, in specially petition number in matter of Deepak Kumar, State of Haryana, the lease of a minor mineral including renewal for area of 5 acres may be granted after getting environmental license for Ministry of Environment and Forest. It is recommended that a minimum period of 9 months mine lease would be 5 years so that eco-friendly, scientific and sustainable mining practices are adopted such and such. So this has been stated. Secondly, he said, however, last portion, in the instant case, in absence of explicit, kindly see, in absence of any explicit or relevant order from any competent authority or from honorable court of law, so required for alteration of his position or consideration of instant application of STML, so laid down under noted provisions of Concession Rules 2016, there is merely any scope to process its instant prayer for grant of STML. Accordingly, therefore, the same is thus rejected at the stage itself. In this regard, it is further advised to take part in e-auction process in respect of the applied area for the grant of LTML in following the related notification published by the concerned authorities. These two aspects have been stayed by the Honorable High Court permanently, not interim stay, permanently stay. tantamount to coercion.
Which two? That environment aspect and the e-auction for LT.
Ultimate. Because the order which has been passed by Justice Talukdar is borrowed from Rule 49.
Pardon?
This order passed by Justice Talukdar is borrowed from Rule 49. Kindly see Rule 49. Rule 49 says, in respect of short-term mining license, kindly see Rule 49, Chapter 3 and 5. Chapter 3 in respect of LTML. Chapter 5 in respect of environmental aspect. I'll show this.
That you have shown us.
Shall not apply to short-term mining license. After borrowing this from Rule 49, His Lordship passed this order. These two requirements are stopped permanently. It will not be required. Now, what they say, after the order passed by Justice Talukdar, the final order which has been passed, can we see this final order? What they say? Order dated 12th of February 2020. This is now under challenge before your lordship. Culminated with the
Appellate order.
divisional order. Parent order is the same. Kindly see. I am not. Second page, the fact appears from plain copy of the WP in the matter. My lord got it?
Page. Appellate authority order.
Second page.
Oh, you are showing.
Of 12th of February 2020. That is at page 49, capital A of the read petition. I have given a loose copy. Typed copy.
17 January 2020.
12th of February 2020. This is the final order.
This was challenged before Justice Shubhra Ghosh.
Yeah.
It was dismissed. Appeal said go and file appeal. And after the appellate authority, you challenged both the orders of 12th February as well as of the appellate authority before Justice Joy Sengupta. Yes.
Now, kindly see this order. My lord, the matter is taken up for hearing. I am not reading entire. In reply, I cannot take
Please show
much
us
time.
the relevant portion. Please show us.
Relevant, for I cannot take much time. Only second page. You lordship kindly see.
Clause 7. You showed
Second
us
page.
clause 7.
1, 2, 3, 4, 5, 6. These are all quoted from my read petition. Your lordship need not read this. These are quoted from my read petition. What I have stated in the read petition.
In paragraphs?
Paragraph, there is no number of paragraph.
Okay, very good. These were quoted from the read petition.
1, 2, 7.
7 also.
7.
7 also quoted.
Up to 7. Then, my lord, can you see paragraph 8?
Achha. Yes.
In terms of sub-rule 1 of Rule 43 concession rules, district authority or any other officer may grant STML as per guidelines to be issued by the Commerce and Industries Department from
This has been done.
to the
Just a
extent
moment. This Commerce and Industries Development has given any guideline?
No.
There is
No guideline. Rule 43 has been quoted here. I am not reading. I will play the Rule 43 at the appropriate hour. This is the Rule 43. Now you will also count the finding. Finding is 10. This is the finding. 10. After the publication of the West Bengal minor mineral concession rules to the grant of prospecting license come mining lease for exploitation of minor minerals shall be made through competitive bidding through e-auction process in following provisions of West Bengal minor auction. I have not applied for license cum mining lease. I applied for short-term mining license under separate rule. Kindly see, my lord, Form A, Form E. I have not applied for prospecting license come mining license. My lord, kindly see chapter 8, chapter 8.
You have applied for 43 short-term license.
That is, kindly see, my lord, Form E, Form E. Form E at page, your lordship will get that at page 1. No, this book you'll do. No,
Page.
this book.
We have.
Page 1.1.55. Page 1.55.
Yes.
Annexure Form E. This is an application. See Rule 44 of the West Bengal Minor Mineral Concession Rule, model form of application for short-term mining license. This is the application I have made along with 3,000 rupees deposit. Thereafter, what will happen? Kindly see Form F. After getting my application, they will consider the same and will issue license Form F. Short-term mining license under Rule 47, extraction development such and such, district granted by description of short-term mining license HTML. This is the license form.
No, read the next paragraph. In view thereof, page 51A, the order which we have understood. Clause 10, you have applied for short-term license, you have said. Now,
I have not applied for license come mining under chapter 8. Kindly see chapter 8. At this stage, you will also kindly see chapter 8. This is separate procedure.
Chapter 8 হচ্ছে
Chapter 8. Grant of prospecting license come mining lease or mining lease or for exploitation of minor minerals. I have not applied under the same. So the entire order is bad. This was not considered by Super Ghosh or anybody else.
Come to the next paragraph.
Kindly see, in view of the above mentioned circumstances, being creature of statute and also being empowered by the Honorable High Court to take a decision on merits, the undersigned officer is also not a position to allow the application for short-term lease. I am not lease. I am not praying for lease. Lease is a separate thing. I'll show from the book. For minor minerals which was submitted subsequent to the date of giving effect to the rules, so the representation of HTML of the representation dated 10th May 2018 is hereby considered rejected. How it is rejected?
All right.
On 10, paragraph 10, it is rejected.
What is your argument as regards judicial intervention?
Now, with regard to judicial
that Mr. Galib has said, Mr. Galib's argument was judicial intervention will be at that stage if there is a direct order towards grant of such license. This was his argument.
Kindly see.
Now your reply to that.
Judicial intervention means, according to me, I will show the authority. Judicial intervention is born on a judicial proceeding. I file a suit or a writ petition, then order is passed by the judicial authority. Is there any law under the Constitution of India that for applying before the district authority, I have to go for suit and writ petition that give me the order to apply to have the grant of license? Is there any law in India under the Constitution?
Sorry, we didn't follow you. What do you say?
Judicial intervention
Is born on a judicial proceeding.
Two things are required. One, I have to apply in a suit or in a writ petition. Then I have to obtain an order from the writ court or the suit that allow me to apply to have the license and direct them to grant license. What is the cause of action? Without any cause of action, can I file a suit? Can I file a writ petition? Without any letter, without any communication, can I file a suit? Can I file a writ petition? What is the meaning in it? This is totally ambiguous word. Assuming for the moment this order, according to me, this order is ambiguous, there is no meaning in it. How, before applying, how can I obtain the order from the High Court? Grant me. On which basis? Will your Lordship allow under 226 in vacuum to come to before your Lordship without any cause of action, without any grievance? Will your Lordship allow under 226 without judiciary?
So there was a cause of action according to you.
It is a totally ambiguous order, ambiguous requirement.
Mr. Bhattacharya, the cause of action according to you arose on 24th May 2018.
Yes.
That is on that basis of that cause of action, you approached the court. Court said this order is permanently stayed and authority to consider revisit it. So, then at that juncture, there was a judicial intervention.
No, herein they say, these rules say, I have to obtain order before application. Can you see Rule 44?
Rule 44.
Can you see?
Yes.
Before application, I have to obtain judicial intervention order. Otherwise, it has no meaning at all. An application for short-term mining license shall be submitted to the district authority or authorized officer in the prescribed form, accompanied by challan showing non-refundable such and such. An application for some mine shall not be granted unless the mining dues of the in case of right and such and such. Application, I have to file application for me. You also can see for me whether there is a column the judicial intervention order is there or not. Can you see for me? Can you see whether for me it has been stipulated that I had to obtain order from the High Court in vacuum before the suit court in vacuum. Is it so easy? It is unthinkable.
No, Mr. Bhattacharya, he's argued this you have argued already. His argument was judicial intervention as incorporated under Rule 43 means when there is a direct order of the court, either a suit court or a
When it will be passed. Where it will be passed?
Mr. Bhattacharya,
If before application, can it be passed?
application you made, it was
No. No. Can you see Rule 44? I have to apply
very good.
first. Thereafter, they will consider exceptional circumstances.
Yes.
Then they will give the license. After application, they will consider.
Yes, yes.
How can I apply after application unless it is unless there is an order? They say order should pre-exist the application. They say the intervention should pre-exist. How can pre-exist?
Suppose you have made an application, that you have made an application seeking short-term mining lease. Suppose you have made an application before the authority seeking short-term mining. That application has not been considered. Challenging that inaction you have come.
Correct.
Court asks that your inaction is not justified, you consider it. Whether that is also judicial intervention?
No. Herein,
What
this,
stage you will-
no,
up
herein,
to stage-
no.
Up to what, from which state you will
Is
start to say that judicial intervention is going on and the condition of Rule 43
Wow.
is being satisfied.
Judicial intervention herein is provided before application made.
Where do we find that?
No, not that.
Otherwise, Rule 44 has no meaning at all.
No. Rule 44 is
Kindly see F.E. Form E. Otherwise, Form E is meaningless.
At that time, there was no judicial intervention. You applied. After your consideration, they rejected. Then, according to you, judicial intervention was taken by Justice Taluk.
That means they want to say
that judicial intervention is not an order.
You'll also will consider in the division bench, appellate court, you'll also can't consider. Judicial intervention will come herein, it is stated, should pre-exist.
Where you are saying that? Where you are should pre-exist?
Pre-exist.
Application
Kindly see,
দরখাস্ত করার আগেই judicial
grant of short-term mining lease.
Not that.
That is not their
application.
There is no precondition that you have to seek intervention of the judiciary first. Then you will.
Then I will apply.
Then you will acquire your entitlement to pay present application or submit application. There is no such.
What is the meaning of judicial intervention?
Judicial intervention by using these words, which Mr. Galib want to say, that when the court applying its mind to the merit of this case will declare that you are entitled to get it. And then it would be relegated for taking next follow-up action.
Now, my lord, kindly see.
If court without applying its mind as regards to determine your entitlement, court relegate the issue to the authority.
Then you'll also kindly see the order 12th of February 2020, which has been rejected. Whether there is a mention that judicial intervention order is not there, they say that you have not applied for an auction. What is the meaning in it? Can't you see the order which is under challenge before your lordship? They say after the publication of the grant of prospecting mining come license, I have not applied for the same.
So you want to say that the ground for my
The order
rejection-
is totally bad. I have not applied for the same.
the ground for rejection of your claim by this order is not on a purported ground that there had been no judicial intervention.
Yes.
This order has been passed on a totally different year.
Yes.
This is your argument. But we are not being able to appreciate your argument that court cannot exercise jurisdiction in vacuum. How in this case there was a vacuum, Mr. Bhattacharya? Justice Talukdar said, I'm permanently staying it. You revisit, and I have not gone into the merits. So admittedly, Justice Talukdar did not, though your argument is it ought to be treated as quashment of that order. In the order, there is no direction that it is being quashed for this reason. There lies his argument. He says that sitting in appeal, whether this court will intervene in the absence of any direct order of the court that grant him license.
Judicial intervention means direct order, positive order. Is there any law?
No, there is no law.
No. Can't you tell us? I have to learn from you, Lordship. Judicial intervention should contain a direction or a mandamus. Can't you see? Judicial intervention means it cannot reject to grant. This is judicial intervention interpretation by your Lordship. How can it be? Can't you see can't you see what blacks say meaning of
No, here please come to the finding of the single judge. Page 10 of the order.
Para 7.
Page 10 of single judge order.
Huh?
Single judge and order.
Oh, single judge.
Yes, which is
Single judge order. Can you
it's
see?
appeal.
No. Can you see page 149?
Yes, no, come to paragraph 7, 150.
50, whatever.
Can you see? What is it?
7.
7. No court has directed respondent to grant any such stayment to the petitioner. This is a wrong order. As such, you have come in appeal. Judicial intervention cannot say grant. Petition. This is a judicial intervention. That cannot mean to grant. Absolutely wrong statement of learned judge. And secondly, can you see, this order cannot be sustained. Another ground. Can you see? Can you see?
Single bench order preceded action. এখানে merits এ শুনটা বলে দিয়েছে।
এই অর্ডার মার্চ করবে স্টেটের সাথে এখানে মার্চ
এটা তুমি কি রেস্ট্রিক্ট করতে পারো যে জুডিশিয়াল ইন্টারভেনশন সেই ক্ষেত্রেই either when it is rejected by an order or is allowed by an argumentation. Judicial intervention তোমাকে appreciate করতে Yes.
Can you see paragraph 11 of the order?
No, paragraph 7, my brother wanted you to.
7. Can you see?
You have
So
read.
far as judicial intervention is concerned, no court has directed respondent to grant such stayment to the petitioner. Directed to revisit, this cannot be treated as judicial intervention. Under this cannot be treated as judicial intervention. No direction to grant will not be judicial intervention. Judicial intervention, what is the judicial intervention?
এখানে যেটা করেছে ওটা রেলিগেট করে দিচ্ছে।
হ্যাঁ,
ও যে বলছে
stay the grounds which was taken in that order will not be taken again. Will not be taken again. But by using this word, the appellate authority has given the scope. Given the schedule, that means he can consider everything. He is not restricted or stopped.
সেটাও যদি rejection is not only done but described সেটাই সেপারেট
ছিল যে সেই গাঁও যখন visit করবে সেই গাঁও court has relieved from participating in the auction for guilty and other. Yeah. So this is
What is your are these 7 lines kindly see? This is the observation you are challenging, na? Paragraph 7. So far as judicial intervention is concerned, no court had directed the authorities to grant any STML to the petitioner.
This cannot be treated as judicial intervention.
Right. Earlier, this court had directed the DLRO to revisit the recommendation.
Yes.
Lastly, the division bench directed the authority to take an independent decision. This cannot be treated as judicial intervention, winning the meaning of the rules 2016. A proper reading of the particular rule and the context would make it clear that a judicial intervention as envisaged would mean a positive order by a court of law to grant STM. So,
I have taken account positive order by a court. Judicial intervention means to pass a positive order. Is there any law? Is there any law? Kindly, your lordship knows this law, your lordship decide the point. I have searched many things. The judicial intervention means to grant. But that means it cannot be rejected. If I file a suit, writ petition, it cannot be rejected. Has to be granted. If that is the law, lordship deciding against me, no problem. If that is the law. Judicial intervention means it cannot be rejected, it has to be granted. So we will come before your lordship, I will show you division bench judgment, division bench said, writ petition comes, get order, go. Judicial. Now, my lord, can you see to what is the meaning of judicial intervention?
But you have told us that you have told us at the beginning of.
Yes. No, I have got the judgments.
About
Next dictionary, I will show you what is the meaning in it.
you have given.
What is the meaning?
You have given on earlier. Oxford.
No, I can't
Black,
see.
whether it is black or Oxford.
What is the meaning in it?
Oxford reference you have given to us.
Oxford, I have given. Then and ambiguity. Can you see ambiguity? Can you see Oxford?
Oxford, we
Oh,
have
no,
got.
I have now. I am giving craze on statute law.
What is reply stage? No.
Only 2 minutes. Craze on statute law. What is the meaning of judicial process?
Give a copy to Mr. Gali. Give a copy to Mr. Gali.
Craze on statute law.
Give a copy to Mr. Gali. We are taking. Hey, down na.
কি বলছেন? নিয়ে নাও। Kindly see. Only one line I am showing. Interpreting words which are ambiguous and equivocal should not disrupt the meaning of such. আরেকটা কোনটা? আরেকটা দাও। Now administrative law, Craig. I've given the mark. Kindly see. What is the meaning of administrative law? Craig said. একটা কপি দাও। আরেকটা আমি দুটো, ওই তো আমার কাছে দুটো আছে, একটা দিয়ে দাও। পড়া দরকার নেই, এখানে যশ সাহেব পড়তে চাইছে না। যশ সাহেব
দেওয়া হবে তখন প্রশ্ন
No, Craig. My lord, I am giving you your lordship.
That is not a ground.
দেখাচ্ছে
What is the play? If you get the HTML today, suppose
only for 90 days.
we
Only for 90 days.
and that
And
means
HTML for
no,
10
you
years.
will not stop thereafter because 90
HTML
days
for 10
given.
years.
Yes, Mr. Bhattacharya would not come before.
90 days পেয়ে গেলে তারপর থামবে না আবার করে।
How can I?
You cannot because Rule 43
How can-
stops from giving it for more than 90 days.
LTML now limited. It is for LTML that means losses. I can get only for 90 days. And you see, my lord, you also remember 24 of Rules 2002 quarry permit. This is now separate. Now rules say
No, we understand it is for 90 days.
only 90 days for 3 hectares. Now I am only for 3 acres, not hectares. And LTML get 10 hectares.
Then suppose after 90 days you will again apply for HTML.
Again, I will have to apply.
দেবে না কেন?
You tell us that you will not apply.
I will not apply.
According to you, you cannot claim for more than 90 days.
No, I cannot continue after 90 days.
This application.
And not to come with any further application for relicense, then
How
it
can I
goes
say?
on.
It is for their decision if because it is for the revenue earning. They will give the settlement.
So then, Mr. Bhattacharya, you will continue for infinity time.
How can I?
Every 90 days rejected,
How
you will
can
again
I?
come.
How can I? Without the order of the district authority, can I? There is a police. The district authority will pass the order. They will execute the order. Can I do this infinity without any order? It cannot be done.
All right, Craze, what you are showing?
In the craze, I have shown before your lordship.
Yeah, judgment.
Craze to দিলাম তো,
ড্রেসটা দিলাম তো।
craze to,
Which portion are you showing, Mr. Bhattacharya?
craze.
এই যে ক্রেজ
Which portion?
Craze, my lord, I have given. Yes. The second page.
Second. দুটো কপি দিয়েছি।
Can you see? Craze.
একটা কপি দাওনি?
আরেকটা?
দিলাম তো।
You gave. Yes, Mr. Bhattacharya.
Can you see? Craze. 10 lines from the top. It is perfectly consistent with that there should be read as applicable and should be applied to those things to
214
which
page 214
page 214.
214 is not here.
Second page.
it's
214.
crazy.
Second page.
Page 2.
Type 191.
No.
214. It a Craig these.
No, 214 is not here. This is up to 193.
crazy টুটা আমি তোমার হাতে উল্টা তোমার হাতে তো
119.
তো দিয়ে আগে দিয়েছিলেন।
Oh, এটা
এই যে এটা দেখুন তো আরেকটা কপি
আবার কি নতুন জিনিস? এটাই তো। Where you are reading?
Craze, you lordship.
ও না, এটা
Not Craze. Craze.
না টেক ব্যাক এইটা ওনাকে দিয়ে। This is not not ওটা not required. এটা দিয়ে দাও। Do you have another copy of this?
Yes.
আচ্ছা, we are reading together.
I am giving a copy.
আচ্ছা, what you want to show?
You have been given a copy.
আচ্ছা, yes, what do you want to show?
Only see 10. 1, 2, 3,
4, 5, 6, 7, 8, 9, 10. Yes.
15 lines bottom
11,
from the top.
12, 13, 14. Yes.
It is perfectly consistent with that. that should be read as applicable and should be applied to those things to which they are in the natural sense apply. Natural sense. Sense cannot be created. Natural sense. Judicial intervention cannot mean to grant and which do not require any interpretation clause to bring them in. And an interpretation clause, said last J, should be used for the purpose of interpreting words which are ambiguous or equivocal. This word, judicial intervention order, word is ambiguous order.
All right. Yes, thank you. Ashok, the learned advocates appearing for the respective parties have concluded their arguments. Stop judgment.
Lord, my learned senior friend, my lord, in the reply,
Give one praise, statute, Lord, another copy.
Grace.
Yes, for my brother.
My lord,
my learned senior friend has used some reference in his reply argument, which was not there at the maiden argument.
No, we have disclosed to him what we have understood from your argument. In your presence, we stated that. In reply to this, he has made this.
No, since my learned senior friend has referred to certain authorities.
No, only he referred to Oxford.
Grace, Oxford.
No, he referred to Oxford at the first juncture.
In order to elucidate the meaning of judicial intervention.
Judicial, only to that.
So I am only on that, my lord. May I
Yes,
just give,
yes,
my lord,
Mr.
respectfully reply only 3 sentences.
Yes, Mr. Gali.
My lord, in my respectful,
Just a moment. Yes.
in my respectful reply to my learned senior friend's argument on the issue of judicial intervention, my lord, may I just, my lord, judicial intervention is, or these two are not independent, separate, distinct words used in the rule of 2016. This is used in the sense of a phrase, judicial intervention. So what my learned senior friend is trying to, my lord, elucidate.
According to you, it has to be
It's a phrase.
Compositely.
Yes, phrase, as per Oxford, it says, phrase is a group of words forming a conceptual unit, but not a sentence. So if my learned senior friend is giving the individual distinct meaning of the word judicial, and again giving distinct meaning of intervention, in that sense, my lord, it will not take us to, my lord, the logical conclusion. Because, for example, if I give your lordship the meaning of minor and separate meaning of mineral, then it will carry a different meaning. In the act, what is minor mineral? It's a phrase, particular meaning has been given. For example, mining operation. If I give your lordship the meaning of mining separately and operation separately, this mining operation phrase will not give a appropriate meaning, which the rule 2016, my lord, wants to carry the meaning of. So it has to be in that, in order to bring out the meaning in the text and context, or my lord, purposive construction and pragmatic, not pedantic. In terms of rule 2016, the word used in rule 43, judicial intervention, we are to, my lord, bring out the meaning of the phrase, my lord, which, my lord, in my, my lord, I have checked up Halsbury, 4th edition, Black's Law, Watton, Stroud's Law Lexicon by Justice Thacker, and Mitra's Law Dictionary. I could not find out the meaning of this phrase. Individual meaning, lordship can get. Second, my second full submission, my lord, that given the meaning of rule 43, where this particular phrase has been used, that under these 3 exceptional circumstances, the state can give STML. Leaving aside judicial intervention, if your lordship, my lord, kindly goes through B, C, and D, these are left with the executive authorities, that they will have to take a decisive decision whether STML are to be given or not in the text and context of the circumstances. So if B, C, and D are to be read with A, judicial intervention, so my lord, this has also judicial intervention, has also to be read in the concept of a positive or a negative order from the judiciary, that yes, after going through these materials on record, either you are to be given the STML or you are not to be given the STML.
Then what remains to be considered?
So
Suppose
consideration is not.
Justice Talukdar has said that I am granting.
Sending for revisiting.
Yeah.
So in our humble understanding, that is the fulcrum of the case, that Justice Talukdar's order.
So you mean to say, as that intervention was there, the court, the administrative authority went into the other aspects to find out whether the exceptional circumstances are there or not?
No. In our understanding, in the understanding of the authority, since the applicant was showing a judicial order of Justice Talukdar, that see, I have brought out an order, the authority was of the opinion that this order cannot be read as a judicial intervention in the text and context of Rule 43, as because Honorable Judge has directed us to consider in accordance with the merit of the case. It's not a positive order. Now, my learned senior friend is telling, if I come to your lordship, it has to be a positive order. Can't it be a negative order? Since the prayer is to direct the authority to give me the STML, that's why the question of positivity came in this matter. It could have been negative also. So authorities of the opinion, Justice Talukdar's order, had it been a positive, that is, yes, authority, you give him STML, then it should be tantamount or akin to judicial intervention, given the understanding in the text and context of Rule 43. Lordship knows, below, the latest judgment of the Supreme Court proposition on the interpretation of statute is, it has to be pragmatic, not pedantic, textual and contextual.
Yes. Thank you, Mr. Vatsal. No. এটার সাথে এই বইটা দিয়ে দেবো। এর সেরকম সাহেব কেউটা বেঁধে দিই। এইটা আমার অর্ডার শিটটা। Thank you.
Grateful to Lordships.
You only one word. In contractual field, whether any clause can be given by any employer or the government authority, then you get an order from the court first, then come to me.
Yes, we have appreciated your argument.
Can there be such law in India under Article 220, Article 21 or 19?
That is why you are before us. That is why the learned single judge has held against you. That is why you are here.
Lordship.
The learned single judge has accepted Mr.
Actually, it is prepared. These particular rules are prepared by some employees. Bad draftsman. You also know the bad draftsman is castigated by the Supreme Court. Bad draftsmanship.
Judicial intervention, Lordship will come across this
In
phrase.
the legislative process, this could have been explained. Had it been explained under the rules, now as there is no positive explanation,
has been added.
you are arguing one thing, he is arguing another. So when the rule was being framed, maybe the authors ought to have appreciated this, that insertion of this clause will lead to litigation. Lead to a deliberation.
Yes. Now,
But that is favorable for you. That is why both of you are getting chance to
now,
One thing, Mr. But I am saying that estimates should be granted in exceptional circumstances. That when rule itself restricted the legislature or
Not
the
be sensible.
With the prefix.
Exceptional circumstances
that
must be
don't give it unless the circumstances is found to be exceptional.
Exceptional.
That means exceptional, that means the word judicial intervention shall be given
Exceptional circumstances, exceptional
It
circumstances.
is not to be given a liberal meaning, restrictive meaning.
Exceptional circumstances must be sensible one. Exceptional must be sensible one.
That is, which is not normal, that is exception.
There is a
Which is not normal.
This is not a sensible circumstances.
So you are trying to say that not give normal meaning. But I cannot give
No, they
normal
say
meaning in a
no.
exceptional
Your lordship has been given
or situation.
Your lordship has been given wrong.
In a exceptional circumstances, I can
Your lordship
expect the normal situation.
Your lordship has been given wrong impression.
Yes.
Judicial intervention cannot include positive order. Where is this?
That means
where is the law?
Hence, this is when the
Where is the
issue
law?
delegating whether that meaning would be so liberal that when issue is being delegated,
What is the law?
That will no more remain exceptional.
intervention would be
What
then
is
it
the-
would be exceptional circumstances whether
What is the order of the DLRO? DLRO says you have applied for
No, that is
prospecting
a
mining
separate,
license.
that is a separate aspect. What my brother is asking is
Say-
a separate aspect.
Your lordship is discussing a matter on the basis of cause of action. Cause of action is that DLRO passed an order, you have applied for prospecting mining license, which requires e-auction. I have not applied for the same. I have applied for the short-term mining lease, which does not require. So, if that order does not survive, I have to succeed in the particular matter. That his order is under challenge very long.
we are thinking about the interpretation of
No,
the
this
phrase
is
or
not
what.
required.
Whatever maybe the
That
intervention.
That did not say so. They say you have applied for the different license.
Yes, we understand.
If you
Well, this is the very commonest phrase, lordship. If your lordship goes through the judgments on environmental laws, this phrase is very commonest term. I came across all the judgments on environmental laws. But what is judicial intervention? Those judgments, my lord, are not clear. So I think these draftsmen, they have borrowed this phrase from that after going through the judgments on environmental laws by the Supreme Court and various high courts. But what is it? They have not.
All right. Thank you. Yes. Call the list. Item number 12.
Should I appear on behalf of the state?
But on the last occasion, your lordship has adjourned the matter.
One person can be said to be intervened into the matter or into an incident.
Through the court.
Yes. That means first intervene. The one onlooker cannot be or transmission who has just transmitted or delegated a duty to others can be said to be intervened into
लिखो तो लिखो।
Yes, my lord. Petitioner married in 1990. The employee retired, and thereafter petitioner paid for family pension. At that moment, she has come to know that her husband has got a first marriage.
Where have you
earlier.
served? Respondent number 6, have you served?
Yes, my lord. I have filed
Directed
the
earlier.
affidavit of service on the earlier occasion.
No, we again directed you to serve.
Yes, my lord, that was not followed by my.
You should have followed that. Next Tuesday, sent an intimation to him, to her. File an affidavit of service.
Next Tuesday.
Yes. কোথায় থাকে না তো? Spot number 6. I'll put. Next, yes, next.
Shiva, I'm applying for the Public Service Commission.
My lord, Mr. Pinaki Ranjan Chakraborty is appearing for the petitioner. He is not available. Kindly make it only not today.
No, no, this way we cannot proceed. We have a list of 100 cases. Every time if you pray for adjournment, is it possible?
No, no, this is first time I am entering. Only not today.
What is the matter?
Lordship, they have challenged the order of the tribunal. It is at
Oh, very good. 2 weeks. Yes. Next. Next.
Next. 14.
They appear on behalf of the state.
No one for the petitioner.
No, I don't.
2 weeks. Yes.
Yeah, please, your lordship, my lord, this is my application. My lord, sir, this is the affidavit of service. And lordship was pleased to direct to by who is appearing for the state. But Tapan Mukherjee, along with Sangeeta, appear, I have served them. But this is a very short matter relating to the completion of appointment of the petitioner. The petitioner's brother, my lord.
Yeah, give us 2 minutes, mister.
It's okay. Really, the giver
Spouse नहीं है करने.
Lordship, Mr. Tapan Kumar Mukherjee is appearing in this matter. He is engaged in court number 26. I am praying for short passover, Lordship.
Brother and sister talking consider the event he was after it. Married
This is employee on
Huh.
This is employee on.
Where is the scheme?
251.
Annexed circular, December
Page.
18, my lord, page 66, my lord, annex FP. This was the notification, my lord. This was the notification. In the notification, column E, my lord, brother or sister in case of death in harness of an unmarried employee, but he was the married employee. My respectful submission, my lord, after the death of the employee, my lord, as there was the male of the family, my lord, and the person who was the employee was issueless. As such, my lord, the petitioner being the brother, my lord, consequently brother and his mother made the
What happened to her spouse, to his spouse?
spouse made the no objection, my lord, on behalf of
Spouse is alive.
right. Spouse is allowed. But she was interested in that, my lord, if the petitioner will get the employment, then he will see the
Let them hear. It is a question of interpretation of the provision. Let them come with opposition. We will.
Your lordship, please.
Hard, Mr. The present the present writ petition has been preferred, challenging an order dated 16th May 2024, passed by the learned tribunal in the original application bracket in short way bracket close comma being way 1018 of 2017. Heard Mr. Harun al Rashid, learned advocate appearing for the petitioner. Where is Mr. Mukherjee?
Lordship in court number 26.
Who is junior?
Lordship junior has not come to court due to her medical urgency.
Stop. The respondents are directed. The respondents are directed to file upon hearing Mr. Rashid Harun al Rashid, learned advocate appearing for the petitioner, and considering the materials on record, we are of the opinion that the matter needs to be decided upon exchange of evidence. Accordingly, the respondents are directed to file their affidavit in opposition within 3 weeks from date, reply thereto if any be filed within within a week after the vacation. Stop. The parties would be at liberty to mention the matter for final hearing after expiry of the period as specified above towards exchange of evidence. Yes. And his spouse
এই এভিডেভিট অফ সার্ভিস দুটো আছে, হ্যাঁ?
Unmarried fully considerable. No, he will go. আর নয় ছেড়ে দাও, তাহলে কারো নাম দেবেন। Are you there? Who is the junior to the Mr. Mukherjee? Are you there?
Arjun Roy Mukherjee is appearing in this matter. Arjun Roy Mukherjee. And
No, not
Earlier matter.
না, তাহলে ওনার নামটা কারো নাম দিও না। Yes. Yes, what? Arjun Roy Mukherjee.
In item number 16, Lordship. Me and Arjun Roy Mukherjee is appearing in the matter for state. I am appearing.
Appointment. The
Appointment for the post of forest officer on the forest service examination. But petitioner is the
2020 order.
no. This is my 2000 last order. All the orders I have annexed. Since 2020, what happened there?
7 May 2024.
Yes. Last order is, my lord, at last page at 7th of May. I have annexed all these orders, but sequel of facts are there.
May I be permitted? করবে না তো? ও তাহলে ঠিক আছে, ব্রিফ নাই আমাদের।
Participated having, because long pending since during the pendency of the panel before publication, I filed the writ petition. The cause of action there. But on the wrong interpretation of the syllabus or subject, Information technology is my subject. It coming within the purview of computer science or computer application as per the
Selection of which year?
20 advertisement 2018. Selection done 2020.
So what were you doing? You should have gone and prayed for an interim order.
I pray application made.
So
In the similarly situated person got the interim order. Subsequently, it has been confirmed and publication.
how can we help you, tell us?
But cause
Courts
of
have
action
been-
there.
Uh-huh.
Cause of action since beginning.
Post hi to nahi. Where will we?
Whether petitioner will suffer in due.
Yes.
They will say. They will say.
Post have been
filled up.
They will say.
Selection process
But I shall come with the judgment.
Recommendation is
During the pendency of the panel, if that is turned down or something else by untenable decision of the authority, Purushottam says since long back. Your Lordship knows that judgment itself.
For what?
Even after expiry of the panel, exhausted of all these.
It is not a question of expiry of panel. It is a question of a loss of the vacancy.
Loss of the vacancy due
Today,
to.
if you succeed,
Yes.
we have to remove one person and
It
give
can be done it can be done by way of new vacancy.
Many things can be done, but in the facts and circumstances of this case, it cannot be done.
Kindly take up next week. I shall show the
But
judgment of the
next
Honorable
week,
Division
no
Bench
case.
also that during the pendency of
Yes, Mr.
it is pending for long.
ये तो नहीं पोस्ट तो जो vacant
If they filled up the post
state government
without considering my case, although similarly situated person got the appointment, whether I shall be excluded subject to correction by your Lordship.
Where have you said that?
Yes, stated paragraph. Yes, page 7. Page 7. I have stated.
You first told us what is the explanation for sleeping for 4 years. To us.
I have not. Kindly come to first order. First order of the tribunal. It is within the within the validity of the panel. Kindly come. If the authority tribunal refuse to pass any interim order that does not subject to correction,
that gives you an opportunity to come to us.
Interim order against I could have.
Interim order refusal you are to. What judgment you are referring?
I shall come. I shall come. Next week I shall come. Next week I shall come.
Next.
Get full
2 weeks. 2 weeks.
2 weeks.
later order be passed. Later formal order be passed.
Get full details.
Hardly learned advocates appearing.
May I take your Lordship's kindly?
Petitioner and the public service government. Today an adjournment has been prayed for on behalf of the state respondents. In view thereof, list the matter for further consideration under the same heading in the daily supplementary list of this court. 3 weeks since. Yes.
Grateful.
Under the same heading করে দেবেন daily supplementary under the same heading.
I am for the petitioner in this matter.
এই করতে চলবে এতদিন দেখা যায়নি করে
Order on the challenge of the tribunal is 4th of July 2024.
It's a difficult case. Minor at the time of.
That is 5 years exemption has been given for taking application. Application was within 5 years.
It was within 5 years.
Yes, application was definitely within 5
When
years.
did he expire?
2013.
The father died on 22nd of June 2013
Notification
and son's application is 16th.
Notification, 5 years notification. Which
I taking your Lordship, first fact. I tell you Lordship the date of death and my application is 16th of February 2018.
16th of February 2018.
And
You applied.
I apply.
You
And
have
date
one
of
attaining majority.
applying material. And date of death is 22nd of June 2013. And page 103, my lord, come. 251 has been amended to the extent that 5 years time is given by notification. Kindly come to page relevant page 104.
104.
1, 2, 3, 4, 5th column.
You have to say son को लिखाना है कि eligible.
No, कि adversary कुछ तो हो ना.
Ki?
You are not adversary to me.
Acha. Who is telling you all these things?
Murder gets June 2000. Undisposed of.
Page 59 दबा दो बस
এবার ও apply করতে
The notification was of 2016.
But this does not.
just page 59 টা দেখাও they withdraw করেছে that's all withdraw করেছে first application যেটা করলো ও তারপরে page 5960 বাস এটা
সেখানে আমি লিখেছি ডিসমিস করেছি
and where it is written remove it.
Submission.
57 এটা কি application
When he died.
Died on, my lord, 22nd of June 2030.
Leaving behind.
Leaving my wife and son.
Wife and one son.
Yes.
So your wife was eligible.
Yes.
Wife was eligible, but she was not competent to discharge. She was
drew.
No, she was invited. Paragraph 6 we have said. She was invited and she was so weak that group D work you cannot do, the authority has said, in course of process. So wife better.
Mr. Bhattacharya,
Any letter,
57
written document that you are not
59 টা কি আছে
competent.
That was paragraph 6 I have said.
Who called you for interview?
The authority, myself, I have been called by the interview by the respondent authorities. That is my interview letter.
So that interview letter.
Kindly come to page 68 for once.
হ্যাঁ ঠিক আছে 59
I was held competent
59 টা কি আছে
9/6/2019.
from CP না
That loan be. Page 68.
Page 68.
তারপরে
Candidate's name.
It is given to 58 to the
Page
wife.
68.
Yes.
68. 68. At the bottom. The entire radiogram message was sent to me. Radiogram message has been received from so and so Joint Commissioner of Police.
appear and produce document
Please direct the following candidates to appear before the selection board
বেটা
at Dojo Center Police Training, so and so. Every candidate required to fulfill the following eligibility: age not less than 18 years, minimum physical measurement. Candidate's name is Manav Mondol.
57 59 withdraw country page 60
64 आगे
Piyali Saha is against you.
Piyali Shah is a larger bench judgment. But here the rule.
Piyali Saha has said.
Yes, minor either.
You are an expert in that line. You to know.
No.
Piyali Saha has
the
said,
rule is there. Rule is there.
No. Rule has come. That rule will be applied. Had the
I was my major at that time. But that interpretation Lordship is to make. That interpretation is required to be done. Rule is there, there were 5 years gap. Why did you give the 5 years gap?
5 years gap is given.
No, if
under any circumstances the lady could not apply or say he was sick or ailment.
No.
Thousands of matters.
But on the date of application, I was eligible.
You were not. Your wife was eligible. Your wife did not apply.
The date of application, I was eligible. 5 years time has been given, breathing time.
Upon hearing Mr. Bhattacharya, learned advocate appearing for the petitioner, and Ms. Shah, learned advocate appearing for the state. Upon hearing the learned advocates appearing for the respective parties, and considering the materials on record, we are of the opinion that the matter needs to be decided upon exchange of affidavits. The respondents are directed to file their affidavit in opposition within 3 weeks.
3 weeks.
Reply thereto, if any, be filed
Who wanted this?
in a week thereafter.
Yes.
Stop. The parties would be at liberty to mention the matter for final hearing after expiry of the period as fixed above towards exchange of evidence. So, পুজোর ছুটি পড়ে যাবে না 4
1 week after the vacation, let it be listed.
1 week after the fact.
ঠিক আছে ঠিক আছে
3 weeks আর রিপ্লাইটা করে দাও 1
weeks
week
করে
after the
হ্যাঁ
vacation. তারপর বলো মেনশন will be at liberty. Yes,
Grateful to you.
grateful your lordships.
good. আবার এসে হচ্ছে। Where were you, Mr. Mukherjee? Which fort? অর্ধেক ফি কেটে নেওয়া হতো।
In this matter, issue is whether
Hey, Mr. Where is that judgment we delivered in your case?
I shall bring it, my lord. The compassionate appointment.
Yes, which we rejected. Can you
I
tell us?
remember it. I remember it.
Little details টা দিয়ে দিও তো। He will bring down a copy of. You did not give a copy.
Give number and name.
Please give the number.
in this matter, issue is whether an estranged wife,
Whether
an estranged wife calling herself as the first wife is entitled to get compassionate appointment and the pensionary benefit superseding the mother of a minor child, a mother of 2 minor child.
you're appearing for
I'm appearing on behalf of the private respondent who is the first wife.
first wife.
Mother of the 2 minor child of the deceased employee are entitled to get compassionate appointment on the principle of immediacy. We are not only hapless but also helpless condition of the two minor child. One is the rectal operation, 2 operation surgery for a 2 months old baby.
In that time, permitted to.
But that has not been
That
has not been considered by the tribunal as well as the.
No, tell us who is first wife?
I am the first wife.
Mr. Nandis trial is the first.
No, I am not.
Petitioner is the second wife. But at the time of marriage, there is no existence of the first wife.
Acha, very good. Your first wife was married when?
Yes.
Mr. Nandi?
Yes, sir.
But so many litigation was pending.
21st of April 2007.
21st of April 2007, you married?
Yes.
And she is estranged from 2008.
Now, my lord, there was a.
No, we are coming to that
Right.
part. Now, this was the marriage. Any sibling, any
Yes.
issues?
Yes. Born on 5th of June 2008.
Son,
Daughter, my lord.
daughter.
Daughter.
Very good. Now, the person expired when?
2021. 2021 on 4th
October 2021.
October 2021.
4th October 2021. Very good. Now, when was the second marriage?
7th of October 2011.
11th of October.
No, my lord. 11th of July 2011.
Kindly come.
11th of July 2011.
11.
No, my lord, the 7th day of October 2011.
Acha, jai.
Page 53. Kindly sees that will be
Yes.
clear.
Yes, tell us how can now you applied for both of you applied for pensionary benefit.
I applied for.
Acha, very good. Now pensionary benefits was not given to you.
Pensionary benefit, I came to know from the order sheet of the London Tribunal that pension has already been given to the first wife without considering my application.
Pension had already been
given. That appears from the order.
Acha,
Into order.
how many issues do you have?
2 infant.
And tell us now. Both are son.
Both are son.
Expired in 2000. So your tenure of marriage was about 10 years.
10 years.
Both are sons.
Both are sons.
Aged?
2 and 4.
2 year and 4 year. Now, first wife and
First wife is estranged since 2008.
that does not deprive him of the
Yes, my lord.
estranged wife does not become disentitled to benefits.
Yes, my lord. I will show the order.
No.
I will show the
My lord, I
judgment
shall place.
on that score. And that is the issue before your lordship.
Very good. We will decide on
That is the
evidence.
issue.
We were thinking otherwise, Mr.
My
Instead
lord,
of whether
the,
Mr. Nandi,
my lord, I tell you a lot.
both of you are deciding separately, na? You stay at a different place, they stay at a
My
different.
lord, whatever the admissible dues have already been distributed among the 4 persons. There are 2.
No, I am
siblings.
objecting it.
Please, sir.
They are
Let
two-
it be affidavit.
There are 2 siblings and the second wife. And my share. It was entirely the GPF and the GISS was done into 4 parts. And they have got their share. If your lordships may kindly text up the page 88, the impugned order, it has clearly been stated there.
I am disagreed that not entire.
And my lord, I shall.
order করে upon hearing the learned
In the meantime, my lord, no compassionate appointment would be given to anyone, my lord.
My lord, I have been already.
I have applied for compassionate appointment, and it is my case that the immediacy is in my favor. Balance of convenience is.
My lord, I am already serving. I am already serving. Why should that be disturbed?
Serving.
already
Yes, I have already.
Without.
My lord, a second wife. I would like to place only one document, my lord.
Sir, you are not fortified by the legal principles. Kindly,
But my child.
kindly calm down. You can seek remedy in respect of the children, as the law stands.
Yes.
As
They have
the law stands,
Yes.
subject to what argument you make.
Yes.
So we were intending as to whether some sort of settlement can be arrived at. But it seems that you people are at loggerheads. You want to file.
Well, I applied for the paramount interest of the 2 infants of the deceased employee.
But that is not the law.
Yes, my lord.
So as this
But the legitimate child are entitled.
Yes, that is a, but your minor children cannot be granted compensation.
That's why I applied for appointment, compassionate appointment. For the paramount interest of the infant child. That is the issue before your my lord.
So where from you are getting a right to apply for compassionate appointment?
Well,
First you have to,
you
it
lost
is an
it.
admitted case of second marriage. Anyway, let us not.
Well,
go into-
immediate
we will
need
hear
is-
on merits.
Well, immediate need is the paramount consideration. But we have nothing. Widow mother and 2 children have nothing. Now they are become state bigger.
All right. At
Well,
least
compassionate appointment is.
at least it has to be decided upon evidence.
Yes, my lord.
That is
But in the meantime, my lord, no appointment was given, my lord.
what appointment? She's a working lady, she's saying.
Yes, I have already been given the compassionate appointment.
My lord,
That you have been given
Yes.
compensation.
My lord, without consideration during pendency of this
No,
application.
it is not so. It is not so. Number one.
But your lord,
And
kindly pass an order for the
Why?
proof.
what for?
Wait.
What for, my lord?
Yes,
My
wait.
lord, the case is this, my lord. My learned friend is placing.
No,
a-
are you serving?
Yes, I am serving. There is no doubt about it. I am serving there.
You got compensation?
Yes, I have been given the compassionate appointment as per the instructions so received by me.
Very good. You disclose that in your evidence.
I shall disclose it, my lord. And my lord, I would like to place only one more document that I was very much married. A divorce suit was pending. Now, during the pendency of the divorce suit, died. Now, my lord, the divorce suit itself is the proof or the evidence to show that yes, I am the married person.
She has 2 minor babies.
Correct, my lord.
Mr.
That
Nandi,
is why
you are a
Major
serving-
operation, my lord.
kindly-
Major operation.
lady.
kindly,
You're working lady.
kindly appreciates one thing, my lord.
But to help
As-
them out, sir. Decide
Yes,
together.
My lord, kindly
finish-
comes to the order, my lord. They have already been paid their share. It
Yes,
has
the
already
9,20,000
been the order. Already been paid.
840 was, but this was
Settle
distributed out.
the issue, Mr. Nandi.
My lord, they have already been paid.
9,20,800,
One sharer got 9.
you divided into 4 shares.
Already been paid, my lord.
2 operation, two surgery has been made of the anorectal malfunction of the
My lord, these are all my lord
months baby.
prejudicial statements because even my child
And only group
also
only,
undergone a very
only
serious major
50%
operation.
gratuity, only 50% gratuity I have got. Nothing else.
My lord, whatever she is entitled to law, she has been given.
I am entitled to 50% at least entire pensionary benefit.
First wife will get the
That
pension.
is the law, my lord.
Pension and what is the 1/4 of the
How he got pension, how she got pension, and how she got compulsory abandonment, that is understood. That's
My lord, how can that be done?
Without
No, sir,
Hindu
we are not
Shastra.
fighting here.
no, my lord.
You are arguing a case. Why you are so excited?
No, my lord. Sorry.
You are not that lady. You are the advocate of that lady. Don't identify yourself with the client. Yes, tell us now. Which order have you challenged before the tribunal? Page 88.
Page 88. This is the second down order. Page 80 is the second down order.
Second round. That is, you went first time, it was directed for
To consider. Then you logically come to the reasoned order also.
Page 88.
8 of the page 80.
No, 88 is the tribunal order.
Tribunal order.
No. Where is the reasoned
order?
Page 80. 80, my lord.
80.
Any settlement was arrived at relating to grant of gratuity?
Yes.
Only 50% gratuity.
That is there, my lord, in the order of page 88. It
Only
has been
50%.
clearly stated that 1/4 share was given to each and everybody. That is
How? If she has a void marriage, how
No,
they are
my lord, my lord, the
Only
illegitimate
the first
oh,
wife,
to the son
son. Yes, my lord,
first
the
wife and son,
son
and 2 sons of
of the
50% given to the first son.
first
wife and
50%
first
to the
daughter.
first son, and 50% to the wife, first wife, and second wife, 2 sons,
50%.
Oh,
total four.
not to the second wife, but to her minor child.
Minor.
Yes, but that is the illegitimate.
And it cannot be encased until they attend the majority.
Yes.
Hmm.
That has been done, my lord.
It has to be kept in a fixed deposit.
So, Mr. Nondi, you cannot sit with him and finish it up. Some sort of this, how long this litigation will proceed? The children will expire.
My lord,
Have some sort of sympathy.
my lord, then I shall ask if that is the
No, you
desire of
sit
this
with
court.
Mr. Bhattacharya.
If
Let
this
the
is-
clients do not fight together. You
And
sit with him.
basically, one
If
part
anything
of
can be
your
done.
family pension to the child, two sons. So long they
I shall
they are-
convey.
Are Baba Darao, you have got compassionate appointment. You have a son which is now maybe a major or nearing his
That I
major.
do not know, my lord.
Major.
I will either.
You and your son have got 50% of the gratuity. You have got compassionate appointment also. Over and above that, you are getting family pension. So this family pension amount, let them survive also. There are 2 minor children. Why don't you apply your good office and settle the issue? If at all it can be. You cannot do something if your client doesn't take. You can sit with Mr. Bhattacharya can sit with
I shall convey
Mr.
the.
Nondi.
You are also mother, although step, but mother.
You're also the mother.
My lord, and one more thing, my lord. It is not the.
Let us do one thing. We are admitting the petition with direction for affidavits. In the meantime, let Mr. Bhattacharya and you please sit with him to ascertain if any solution can be arrived at. Then in that case you mention before us. We will take up the matter and solve it.
Yes, and a considerable amount has also been spent on my part on the health and the expenses, my lord. She was also very sick. Even her leg got fractured. And I have all the documents with me. Kindly have a look.
You have a
Hospital there, my lord.
you
Bangalore.
you have a talk.
We
with
are
the
not
client.
saying that
Ah.
family pension you are getting. It is not that we will take away your family pension.
I
We are
understand.
requesting you
To
I
find
understand.
out a solution, suppose you are getting 100 rupees. If you can spare 30 rupees from that, what is the problem? Let the other two children survive.
I shall convey the wish of this court. I shall convey the wish.
All right,
Definitely.
tell us, this will continue till his son, till a particular time, we will say.
Till they
আরে
attain
two-
majority.
না মেজরিটি তো কবে পাবে? Two babies, 2 বছর আর 4 বছর. We can fix the tenure also if you so desire.
I shall convey the wish of the court, my lord, to my clients, and definitely, my lord, I shall convey the wish that this
আমরা কিন্তু পিপি একটাই
compassionate but my lord, kindly hears what Mr. Mukherjee has also to say.
One PPO and
Yes, we will not disturb that.
It would be in terms of the order of this court.
no, another tether.
Compromise. We should be fast on compromise.
We shall have to issue one bank account should be transferred.
হ্যাঁ
If he wants to transfer, we have no objection.
সেটাই তো বলছি. Have we asked you issue another PPO?
But
Then
my
let
lord,
us do one thing. We simply keep it after 2 weeks. You come and tell us. If there is no solution, you bring the papers which you have got in the meantime. We will consider the matter.
on merits, then it will be decided.
On merit, if the records are here, we will
I shall file the affidavits, my lord. Then let there be a direction for filing of affidavits.
direction হয়ে গেলে আর settlement হবে না.
No, my lord, it is not that. It
No,
is
no,
not
your
that.
lordship can take it up.
It is not that, my lord.
As a
We will take it up. We will adjourn it today. We will take it up after 2 weeks. In the meantime, let Mr. Bhattacharya sit with you.
No,
I need to send. I shall convey the wish of
You
the
have
court
to
to the
sit
client.
with your client first.
Yes, that is the.
Then the second sitting will be Mr. Bhattacharya. Okay. You sit.
Compassionate
there
appointment
also
has
your
been
son-
given.
One
But
person.
behind-
My lord,
not
my lord,
only
whatever
behind
it
the knowledge of
might
the
be, my lord,
petitioner.
but the fact remains that what my learned senior friend is arguing. If you go by the strictures of the law, my lord, then she is not entitled. If you go by the statutes, I understand that.
There is a gross pollution.
আমি কি করেছি নাকি বিয়ে করতে? আমি তো বিয়েই করতে চাই না।
Heard the learned advocates appearing for the respective parties. Please the matter for further consideration under the same heading in the daily supplementary list of this court on আছে কত তারিখ? On 17th September. In the meantime, we
My lord,
request-
kindly give me, my lord, one more week, my lord, 24.
in the
Well,
mean-
20th
see-
September instead of 17th.
Uh-huh.
Instead of 17th, my lord, 20th September.
Yes, 20th.
the matter on 20th September. Miss, we can. We request Mr. Bhattacharya, learned advocate appearing for the petitioner, and Mr. Nondi, learned advocate appearing for the respondent number 5, to make a sincere endeavor
Private respondent.
to make a sincere endeavor
6, my lord. Respondent number 6.
towards
পুলিশের চাকরি যেতে দুটো করে
settlement of
দিই,
the
অন্য কোথাও
dispute.
নেই।
Towards settlement of the dispute between the petitioner and the respondent number 5.
6.
This was number 6.
My lord, may I get one more week instead of 20?
Puja will.
Then, if the settlement is not arrived, ultimately that affidavit will go. We are making an endeavor if this problem can be solved. 24th তে করে দাও, 24th September. All right?
মঙ্গলবার। Yes.
But see that it is done. See that it is, at least you make an endeavor.
My lord, I shall try my level best, my lord. This much,
You
my
also,
lord.
Mr. Bhattacharya, you also keep contact with Mr. Nondi.
My lord,
If you can
definitely, my lord,
settle
I shall convey the wishes of this honorable court, my lord.
Yes. Tell them that
My lord.
for the whole life dispute will remain. They will feel themselves deprived that everything they have taken, nothing has been given to us for the whole life.
All this.
Well, I have judgment, my lord.
They are fortunate to have
Paramount interest
you
of
have
the
not
innocent
initiated
child of the
this
deceased employee
for
is
second
to be
marriage.
taken into consideration
Yes.
before granting
That is
compassionate appointment.
Then you are not agreeable to this proposal?
Yes, my lord.
No,
Obviously,
no,
and your
to
lordship.
this,
I am
if you
telling
say so, then otherwise we will fix it up upon exchange of affidavits. If you are not desirous,
My lord, now I am begging before the state. Now I am begging. I shall be begging.
Why are you saying that
no,
begging?
why you will beg?
Yes, my lord. That is the condition at present. my
But
lord.
the advocate, we have requested you advocates
That is
to
the condition of the. That is the condition of the poor mother.
With the deepest of interest, only prejudicial things won't
Yes,
do.
next
You have to
matter.
go by the rigors of law.
On the last session, Lordship, I had to collect the searching slip after 15th of July 2022, whether the matter was listed or not. Yes. Hello. Kindly, yes. Searching slip, your Lordship asked me to collect the searching slip, whether the after page 47, after 15th of July 2022, whether the matter was listed or not.
It was not listed.
Not listed. Kindly take it up. I have bring the searching slip and list of dates. Call me.
So we are not receive any instruction, Lordship. Give me 1 week accommodation, Lordship.
What is the main matter about?
Main matter, counting of my temporary service for the granting of pension in view of the judgment of the division bench affirmed by the Supreme Court. Well, since 1981, I am continuing the temporary service and I have been given appointment in 1997. So I have total period of service.
Total period of service is
47 years.
97, 2024.
Yes, I have 2004, I have retired. I have appointed in 1981.
2004.
7 years.
1990, 100, 1, 2, 3, 4. Oh, qualifying service not there.
Not there. Well, there is a division bench judgment by the Supreme Court that temporary service should be counted for granting of pension.
That has to be given by the, considered by the tribunal first, not by us.
Justice. Mahatma. And that was upheld by the Supreme Court also.
Which one?
This is 2014 3 CHN Calcutta 608.
What was the deficit?
Divisible total period should be counted for pension. Same department.
Have they exchanged their affidavits before the tribunal?
Yes, yes. They have not denied it.
Then when is the next date fixed?
No date has yet been fixed. Well, I am not getting. My husband died. Now I have the application for substitution is allowed. Since 2020.
You take instruction as to whether any date has been fixed and as to whether you have filed your reply to the original application.
That is on 21st of August I applied for searching. No date has been fixed. Since 2002.
Well, shows that no date has been.
Hand over the copy. Lordship, kindly see. Well, first 15th of July, whether the OA number such as listed and author or not. No date. No date, no order was passed. Next matter same, but matter all of a sudden appeared without any intimation, and that was subsequently after 2-3 days dismissed. I have applied for recalling application that has been. I mentioned the matter before the tribunal for early hearing court refused it for not in a position to hear.
Shortfall by 3 years.
Yes, more than 3 years.
So was that judgment?
Yes. Zero copy. Copy. Paragraph copy. Kindly come to paragraph 13 and 14. 18 also. 13. तो जाने पहले 14 पहले 14 613 80 that Kindly come to paragraph 18 last part. That is completely clear. Paragraph 18 last part of the judgment. However, these judgments are not relevant in the facts of today. We have considered the DCRB rule independently, and in our opinion, the period of service rendered by the government servant on a temporary basis must be reckoned for the purpose of qualifying service and consequent payment of pension, provided that the service be followed
So,
immediately.
Mr. Maiti, this is surprising that how the tribunal will not fix a date also.
Illate, my lord. I mentioned personally, or no, I will not take up. Another matter, all of a sudden appear, I don't know. Last 3 days appear, I don't know. Ultimately dismissed, I filed a recalling application. With application for condemnation of delay allowed, registration dismissed. Next matter, arising out of the same. Both the matter fixed on the same date. Mala, I have nothing to say about the tribunal. There is nothing. Kindly take up this matter here, ma'am. And that judgment
Yes, Mr. Mukherjee. Mr. Mukherjee. What is happening?
Lordship,
The tribunal.
No judicial member, nothing. What administrative member is
The man who is
giving justice to the
we have done our
of the
duties.
state government.
We have done our duties. Let the
No, your member will not even fix a date for hearing. Your member will not fix a date.
certainly
There must be some information slip given. He is saying that I have mentioned.
Yes, I have mentioned it in my.
How the tribunal is functioning. The learned member will not give a date. All right, there is no date.
the registry will give it.
Registry
Registry will give it.
I have filed an application. Registry refused to accept, or no, such application will not be accepted.
To submit a report through Principal Secretary, Law and Justice, Department of Law and Justice.
You put this in a short evidence.
Next week.
Lordship, I am led by Mr. Somnath Ganguly.
Who is your senior?
Somnath Ganguly, Lordship, I am led by Mr. Somnath.
Tell Mr. Somnath Ganguly that we are surprised to note that the tribunal is not even fixing a date for hearing. Ask him to contact your advocate in tribunal, and he must positively inform us that what is the state of affairs.
I'll take back that portion.
Take it back.
Yes. Both the matter next.
No. This is a different one.
Yes, that is the only dismiss for default, because I have no date has been matter fixed on 15th of July 2020. On that date, the matter was not listed. All of a sudden, appeared on 18th. I don't know. After 3 days appeared, ultimately dismissed. I filed an application for recalling as well as a condemnation of delay. Application for condemnation of delay allowed, but the recalling application dismissed.
No, page 9, kindly see for a moment.
Yes.
Mr. Mukherjee, you gave us that judgment that 226 that court cannot.
Yes.
That was
2009 15 SSC.
2009, no?
2009 15 SSC. Just a minute.
এই দাদা 15 তারিখে লিস্টে ছিল, 15 তারিখে লিস্টে ওঠেনি, বলে দিয়েছে
2009
15 SSC. Just a minute.
কি বলছো তুমি?
আমি লিখে নিচ্ছি। 15 SSC page.
Just a minute. Yes. This was from state of West Bengal versus from Calcutta High Court.
সমর কুমার সরকার।
Yes, just give me 1 second.
কোনটা?
ব্র্যাকেটটা না দিলে আসবে না তো।
সেটা দেখে নিতে অলরেডি এই দুটোকে ওইটা ওনাকে ফেরত দিয়ে দাও, এই একটা জাজমেন্ট দিয়েছে।
2009-15 SSC 444.
পাঁচগুলো
Page
ফেরত দিতে হবে।
Page 444.
54
No, no. 444. State of West Bengal versus Somar Kumar Sarkar.
হ্যাঁ
স্টেট অফ
স্টেট অফ
State of West Bengal versus Somar Kumar Sarkar. Can you see paragraph, page 9?
অলরেডি উইল লুক ইনটু ইট। কাম এই দুটোকে নেক্সট উইকে রেখে দাও। ইউ উইল ফাইল এ শর্ট এভিডেন্স।
এটা 15 তারিখে ছিল না দাদা, আমি তার সার্চিং স্লিপ দিয়েছি, হঠাৎ করে 18 তারিখে দিয়ে দিল, আমরা জানিও না।
দরকার নেই সেটা, তুমি স্টেপটা বেরোবে।
নেক্সট টুইসডে, নেক্সট টুইসডে next Tuesday.
Chandra Kumar's case, Supreme Court has said that before going to the tribunal, you cannot come here.
I'm going to the tribunal.
Before adjudication of that, you can.
If I have not a position, I have filed a review application since 2020. Till that, no date has been fixed.
Now, why High Court has not been able to dispose of the second appeal?
That kindly.
Which second appeal?
Second appeal.
But at least I have appeared, at least 15 to 20 second appeals there is.
My learned friends,
89, 90.
tribunal now.
Nobody can be blamed because
So
of
that
the,
I will not get the
from
pension.
March 2020 to 2023, there was a.
Tell us when do you want with that affidavit you file?
Yes, yes. I'm by next Tuesday. The matter fixed on Tuesday.
No, let it be there on 17th.
All right.
17th. ওই দুটো ম্যাটারই 17 করে দিও। ইয়েস ডেকে দাও। না না এটা ডেকে দাও না নেক্সট। ইয়েস 21
Abhijit Sarkar. My lord, in this matter, Mr. Abhijit Sarkar is appearing for the state, my lord.
I am filing the affidavit of service, and one service has been returned with component number 3, with a note that left. Response number 3, state authority. The Chief Conservator of Forest, Western Circle, the West Bengal Survey Building, Gopal Nagar. It has been returned with this note. Whether it may be kept on the record or I shall serve.
very good. What is the order you have challenged?
Yes, I am coming to that.
Have you served upon the private respondent?
Yes.
I am appearing.
I have. Oh,
Respondent number 6.
I have.
You are the second wife.
No, I am the legally married wife, my lord. First wife, and without divorcing.
Where is your first wife marriage certificate?
Marriage certificate in the year 1967, my lord.
So
74 years old. Marriage certificate.
then how do you prove to be a valid man?
Kindly come to the, which is a judicial proceeding, my lord. Kindly come to the, it has been established.
Now she is receiving family pension.
No.
She is
Yes,
receiving.
she is receiving family
And
pension.
did you get gratuity and other benefits?
Everything.
You have got.
I am legally married wife, my lord. That has been established by a judicial.
We are wanting to know, madam, are you getting your gratuity? Have you got your gratuity? Nothing you have got. Acha, tell us what happened.
I was receiving maintenance. I was thrown out of my house. I am still, my lord.
When were you married?
My lord.
When were you married?
1967.
Date.
My lord. She also does not know. She belongs.
Yes,
to
then
village,
tell us what happened.
Village lady, my lord.
Tell us what happened.
My lord, P1, my lord. Kindly come. This is a judicial proceeding. Please, sir. Kindly come to my
The
lord.
Doymonti
This matter
Sonar.
was filed by me. That is the Damanti Sonar against Anathram Sonar, against her husband. This was filed for under section 125 of CRPC for maintenance, and several witnesses were adduced, evidence adduced, and it was established that she is the legally married wife of.
Are in
And-
125 application, there
120
cannot be determination about your marriage.
No, that can.
No, marriage I cannot, but the other document shows that the Anathram, she is the wife of Anathram. All the
And
documents.
next what happened?
witness.
Next what happened? Show us.
Page 38, my lord.
Yes, we have seen that. Then who preferred the criminal revision?
Page 38.
Criminal revision before this High Court was preferred.
Against this order, maintenance was granted to me. Against this order, Anathram moved before this Honorable High Court. Page 57, my lord. And the order of the Honorable High Court was, order of the lower court was, what was it? Affirmed. 60. 57, 60, my lord. Kindly 62. Page 62. It starts with 61, 62. It starts with 60, my lord.
Yes, Mr. Nondi, you are the second wife.
No, my lord. Because only, my lord, mayor maintaining 125 cannot claim the vote.
When were you married?
Married, my lord, I have stated, my lord. No, my lord, I have.
You are getting family pension since 2021.
No, 21. Because my lord, 21, my lord, after the demise of that husband, my lord.
Are you getting family pension?
Family pension.
So your marriage was earlier to her marriage.
I do not admit, my lord, the marriage was solemnized between the suspects. Pension has been granted, my lord.
Without making any inquiry, how they disburse the family pension in her favor.
On the basis of
under,
service record?
my lord,
On the basis of entry in the service record?
service record, and she is a nominee. In the order, your lordship says
Yes,
that-
service record, my lord,
Nominee.
His name, your name has been nominated.
Nominated. Actually, or one thing, my lord, which letter is very ridiculous. Kindly come to.
Ridiculous.
কত page আছে? That
All right, let
but
them
he wanted to know.
He's already enjoying since 2021. Let them come with the affidavit, we will finally decide.
No, only because, my lord, I am asking for a supplementary affidavit. They have stated that no copy of the supplementary affidavit has been handed.
Supplementary you have filed.
Yes, your lordship will find the order.
But it was before state tribunal, not
State
here.
tribunal, my lord,
State
supplementary affidavit, they have not served to us. If it is reflected, my lord, the order sheet, the supplementary affidavit is there.
In this matter, supplementary affidavit for today is first day, my lord. I am happy.
No. Before
you have filed any supplementary affidavit, please give a copy to him.
I have now.
লেখা আছে,
Where it is.
It was filed by the learned advocate before the state tribunal.
That is what we are saying.
ওখানে দিয়েছে।
আর কি প্লিডিং দেবে? প্লিডিং এক্সচেঞ্জ করে নি আর where is your original application?
Original application I have
Annex.
I have read.
OA reply, rejoinder, nothing, no supplementary affidavit.
Rejoinder reply you have filed?
Yes. Your lordship filed the order sheet. It is reflected, your lordship will see.
Then please bring those on
Bring
record.
those. Okay.
Next day I will.
My supplementary reply, rejoinder, supplementary affidavit and
Supplementary affidavit and rejoinder is not on record, my lord. Because I have obtained, because I didn't have any document. I was not appearing there. Somebody else was appearing. So I obtained certified copy of
Where
the
is your
letter,
rejoinder?
and I didn't find on the record the written objection. It is mentioned here, but on record it is not there. So record may be called for from there. It is my prayer.
so if you have,
Yes.
give it. That is reply. That is called reply.
Let them provide
Re-
me.
Give a
reply-
copy of the reply to her.
Your reply on the part, I am the private response, reply on the part of the state, not for my, on my.
Filed any reply before the tribunal?
No, I have not filed.
State has filed.
The state.
Also,
And the
so you
private
bring a
respondent, my lord.
supplement, we are giving you leave You file a supplementary incorporating the original application and the pleadings exchanged by the parties before the trial. Whatever is there with you, you bring it on.
But it is not on the record. Well, I must.
If it is not there, you bring what?
Written objection is not there on the record because I have obtained the entire certified copy. I have obtained from there.
You will make this amendment.
The
in
learned
supplementary
advocate appearing for the
that
petitioner
it is not on record.
prays for leave to file a supplementary affidavit to bring on record the original application and the pleadings exchanged by the parties before the learned trial. Let such supplementary affidavit be filed within 2 weeks with copies to the learned advocates who have entered appearance on behalf of the state respondents and the private respondent number 6. List the matter for further consideration under the same heading 3 weeks since. Yes. And in the daily supplementary list of. Yes, next 22.
Slip
Yes, 22. Who is there? Where is Mr. your other side?
22, I appear for the petitioner,
Mr.
state, your lordship.
Mr. Bhushan was appearing, no? No, this is another.
20. Item number 22, your lordship. अच्छा चलो
এটা ওই মাম counting of past service.
No.
Shortfall of 4 years.
4 years.
Past service.
Item number 22. Pushpita Chakraborty.
All the pleadings are on record.
My lord, the state.
Reply rejoinder is there.
No, my lord. No, my lord.
Reply rejoinder.
Reply was not filed by the state.
They have not filed. To file your opposition, it has to be decided.
Yes, your lordship.
They have not filed a reply.
Your lordship, in any event, your lordship, there has not been a continuous service, your lordship. He had worked as a casual worker till 2008. There was a break in service, and thereafter he joined as Group D staff in 2009.
That break in service.
Your lordship,
Means you are admitting that he was in service.
he was a casual worker, your lordship.
No. If he was a casual worker, if there was a break, why did you allow him to join?
Your lordship, thereafter, your
No,
lordship.
why did you? So, do you accept his status as an employee then?
No, your lordship.
So then
He was
why
a
you are
casual
making such
worker.
submission? We'll
I shall
consider
file.
that. Upon hearing the learned advocates appearing for the respective parties and considering the materials on record, we are of the opinion that the matter needs to be decided upon exchange of affidavits. The respondents are directed to file their affidavit in opposition within 2 weeks.
3 weeks, your lordship.
3 weeks, reply thereto if any be filed within a week thereafter. List the matter for further consideration under the heading returnable motion mention 1 week after the vacation.
My lord, kindly, if you lordship, kindly, my lord, the person is now, my lord, has become old, my lord, has been suffering from various old age diseases.
We have kept it. We have to give them the time to file the opposition. Yes, next.
My lord,
23.
Similar matter, what has happened, my lord, after filing of the affirming of the
23
application?
years.
Yes, my lord. The petitioner, my lord, unfortunately died, my lord. So we have to file a application for substitution.
Mr. Dr. Cordon, learned advocate appearing for the learned advocate submits that after filing of the Mr. Dr. Cordon, learned advocate prays for an accommodation to take appropriate steps since since due after filing of the present writ petition, the petitioner has expired. In view thereof, let the matter go out of the list for the present. Stop liberty to mention. Yes, next 24. 23 you were there?
Yes.
আচ্ছা তাহলে ওই মিস্টার মুখার্জির নামটা দিয়ে দিন। Yes, 24.
24 I am বল 24 তুমি?
22, 23 দুটোতেই ডক্টর করণ। 24 who is there? Petitioner নেই। 2 weeks. Yes, next 25. Yes, Mr. Niyogi. Yes.
And this is a very unfortunate case, my lord. Only because there is no bench, that's why my case has not been taken up for hearing. What is the peculiar case, my lord? My client entered service in the year 1984 as a GDA. In 2014, my lord, he was dismissed from service without holding any inquiry. My lord, I challenge the order of dismissal that was set aside by the learned tribunal. Government of West Bengal preferred an appeal, and the division bench of this honorable court, my lord, in elaborate judgment discussed that in such a way dismissal order cannot be passed. And the division bench, my lord, fixed a time, fixed such and such date, charge sheet is to be completed. They have violated such order, and they have dismissed me from service without reinstating me. That is challenging that I have gone to the learned tribunal. Learned tribunal, my lord, adjourned the matter on the ground that a bench is not there. It is a case of 2020. You also kindly, first of all, kindly see the division bench order of this honorable trial.
What is the Supreme Court? Why did you go? Why did you go to Supreme Court?
My lord, that's it. That I can say.
And you have annexed a copy of the order?
Page 114.
Yes, yes. That I can say.
Shall give a request, assign reason. Bojo. Supreme Court directed till still tribunal has not done anything.
No, my lord, kindly see the order. It has been fixed on, my lord, kindly see. It has been fixed on, my lord, kindly see the order of the learned tribunal.
10th of December.
10th of December.
So you didn't tell him that the Supreme Court has passed this order?
Yes, that has been annexed in the petition. That has been annexed in the petition.
So your advocate was not there. Advocate was not there.
My lord, kindly see the, my lord, surprisingly
An
enough,
application
when the advocate, when the advocate on
we are
record,
disposing it off with liberty to file a preponement application annexing the copy of the order passed by the Honorable Supreme Court.
I'm excuse me.
114 is your Supreme Court order.
Yes. Well, this is in the petition. This is in the original application. This is in the original application of 2020. Well, kindly see. This is the annexure to the original application. Annexure to original application.
Please tell us, Mr. Niyogi, this 114, why did you go to the Supreme Court? Where is your SLP? Because Supreme Court has said that the tribunal, we are requesting the tribunal to give appropriate priority and hear the matter.
Well, this order I find it has been annexed in the original application.
আর কি দেখতে চাও?
Well, kindly excuse me mentioning it has been annexed in the original application.
এটা তো স্টেটমেন্ট করেছে P12 হিসাবে অ্যানেক্স করেছে।
আচ্ছা ওয়ে 350 358
P2
P12.
annexure is the annexure in the original application.
পেন্ডেন্স এইখান থেকে
সেম অর্ডার এটা অ্যানেক্স করেছে অভিযোগ। You have to file an application for preponement.
May I pray one thing? My lord, kindly direct the single judge to hear this matter. My lord, kindly direct to hear this matter on that particular day or earlier date.
No, the date has been fixed on 10th of
That we
December.
can we do that when the Supreme Court has passed this order? Because this was not brought to the notice of the tribunal, Mr. Niyogi. Otherwise, they
it
wouldn't
is
have
an annexure to the original application.
Maybe it was not pointed out to the tribunal. You ascertain from your advocate.
Kindly see the in order. No one appeared for the petitioner.
দেখেছি বলেই তো জিজ্ঞেস করছি।
No, but I said, your lordship, only because the learned advocate on record was not there. That's why name has not been named there. On the consent of the council, it has been taken up.
এটা দিয়ে দিচ্ছে এখানে এদের একটা ছেড়ে order দিতে।
Well, only because the advocate on record was not there. That's why appearing advocate's name has not been recorded.
There is a non-application of mine.
Second page, on the consent of the council, matter was taken up. Without the consent of both the council,
What
it
is
can't
your
be taken
prayer
up.
before us?
My lord,
What is your prayer before us?
my prayer is twofold. Either your lordship decide the matter or your lordship direct the tribunal to hear the matter candidly. My client has already retired. In view of the division bench judgment of this honorable court, specifying specific date when it is to be completed, they have violated the total order. And they have passed the order of dismissal without reinstating me. Without reinstating me in service.
Then why didn't you file contempt before the division bench? If without complying with the division bench order,
because my lord, they have already passed an order of dismissal. That's why I have gone to the
in
tribunal.
violation of court's order,
Yes.
so then it ought to have been taken
It
up
ought to have been taken. But only because they have passed an order. That's why it's a fresh cause of action. That's why I have challenged it. In that application, I have taken that point.
Mr. Niyogi, the tribunal, the Supreme Court has not said that you take up this matter by a single learned member. Try to understand, please.
Yes.
Now, if we pass an order which directing the single member to consider, that will be contrary to the order of the Supreme Court. So how can we assist you? So we can please think over. It is not that we can do this much. We can give you liberty, stating in our order that Supreme Court has passed this order,
I leave it to your lordship.
so that you can prepone it and hear it.
I will leave it to your lordship. I will kindly consider this. This is a poor group D
No,
employee.
don't leave it upon us. We are wanting to know from you. It's a
Your
peculiar
lordship-
set of circumstances, or come prepared that in spite of our tribunal being the court of first instance, we can take it up and hear it finally.
Your lordship can hear this matter. Your lordship can hear this matter. When the tribunal is unable to take up, your lordship can take up the matter.
ওখানে অ্যাপ্রোচ না করে আসবো, এই অ্যাপ্রোচ করে তো এই হাল। All right, come next Tuesday, we will go. এই ডেকে দাও। আর কেউ আছে?